Morning, Mr. Ombudsman. Morning, Advocate Mele.
Morning, everybody. Mr. Becker, I'm sorry for this, for the delay in starting today, 9 minutes later than the scheduled time. But let's see how far we can go. May I just remind you that you are still under oath, and if I recall, you were just about to begin your testimony in responses to Mr. Lonwabo Tsotsobe's contribution.
Yes, thank you, Mr. Ombudsman. That's correct. I'm going to deal with the allegations from Mr. Tsotsobe, and I'll try to be as brief as I can. I should not be longer than an hour, as I said to you yesterday.
Yes.
I've gone through my evidence and tried to cut pieces here and there.
Yes, Mr. Chula.
You remember the agreement yesterday was that we will ask you questions after each and every year. So we will reserve our questions in respect of Alviro, and we'll ask them when you are finished with Tsotsobe.
Okay, thank you. Thank you. That's helpful, Mr. July.
Sure.
Okay, in relation to Mr. Tsotsobe, some of the allegations are the same as Mr. Peterson, so I'm not going to go into too detailed responses on those. For instance, Mr. Tsotsobe also makes the allegation that CSA, apart from Mr. Lorgat, and to a degree, Judge Ngwepe was in the dark, he says, in relation to what actually occurred. And he also states that Mr. Beck and Mr. Lorgat were in full control of the investigation. And I've already dealt with those allegations somewhat yesterday, so I'm not going to dwell too much on that. Clearly, they weren't in the dark, as I explained, and yesterday. And I was not in full control of the investigation. As such, I was an external party, and I did not have the authority to be in full control because I took instructions from my client. Then, if I jump to 240, paragraph 240 of my affidavit, Mr. Tsotsobe, in his oral evidence, he expressed surprise that he never met Judge Ngwepe, and he says he only ever dealt with me or Mr. Cole. And this perhaps deals somewhat with the question that was raised by Advocate Mele yesterday, and perhaps I need to explain that. Mr. Tsotsobe goes as far as saying that it was unprofessional that he never met Judge Ngwepe. But perhaps, as I said, I need to explain what his role was here in a bit more detail and why that was appropriate, in my view. So Judge Ngwepe was the independent chair of the anti-corruption unit, and it would not have been part of his remit to attend all the meetings with the various players, the interviews, etc. His job was to oversee the work that Mr. Cole was doing, and from time to time to receive advice from myself as an independent external advisor. And he would have been able to see, because the meetings were recorded, he would have been able to see the videos, the transcripts, if needs be. He was overseeing it. He wasn't in the trenches, so to speak, but he knew what was happening. And this is very consistent with the ICC protocols when they do their investigations. And I make reference to Sir Ronnie Flanagan there, who's the chairperson of the ICC anti-corruption unit. So when I was at the ICC, and we conducted match-fixing investigations, such as the one in 2010, which was a very high-profile one. You know, he wouldn't have been in those meetings interviewing the players as such. Had there been a hearing, then of course he would have appeared, and he did appear in that case. And similarly, in our case, had there been hearings, then Judge Ngwepe would no doubt have appeared in those hearings, and he would have, you know, his presence would have been felt there. Secondly, you'll appreciate that once these players got lawyers on board, then it was standard protocol for me to then engage with the lawyers, right? I think you would appreciate that. You know, once these players had representation, the correct course of procedure was for me, as the lawyer for Cricket South Africa, then to deal with their lawyers. And I think that would have been, that's entirely appropriate, in the same way that in these proceedings, SJN proceedings, you know, if a respondent has a lawyer, then Mr. July would deal through that lawyer. So I can understand how Mr. Tutobi would have got the impression that Judge Ngwepe was not involved, but that in fact wasn't the case. And as I said, if there were hearings in this matter, I've got no doubt that he would have been present. Then, and I refer in my affidavit again to the statement of Judge Ngwepe, which is included in the bundle, and Mr. Lorgat's own affidavit. Moving swiftly on, Mr. Tutobe again alleges that CSA and its lawyers controlled the narrative about what was going on inside the investigations and suggests there was something improper about this. But I've already dealt with that yesterday. There was no narrative to control. It was an internal investigation as such. He goes on to make allegations about stories, what was happening inside the investigation being leaked to selected journalists. And these leaks, he says, were designed to cast him in a bad light. And I've dealt with that again yesterday. I deny that leaking any information. I think that would have been counterintuitive or certainly not constructive. Then moving swiftly to paragraph 245 of my affidavit, Mr. Tutobi refers in paragraph 19 of his affidavit to the charges that he received in terms of the charge sheet. And then in the following paragraph, paragraph 20, he goes on to explain the process. And unfortunately, that paragraph is incorrect. All four of those statements in that paragraph are incorrect, and I think that reflects confusion as to the process. But the process was set out quite clearly in the code, and Judge Ngwepe's role has been made abundantly clear in the various CSA press releases. But I need to just deal with this briefly. He goes on by saying that the charges, he says, were meant, the effect of the charges meant that he was to be subject to a disciplinary hearing by CSA. And that's not necessarily the case, obviously. That would only have been the case if Mr. Tutobi had contested the charges. And as it happened, a sanction agreement was entered into, and it was not necessary to go to a disciplinary proceeding. Secondly, he states the disciplinary hearing was to be presided over by Judge Ngwepe. But just to clarify here, Judge Ngwepe was the independent chair of the anti-corruption unit. He would not have been part of the hearing, he would not have been part of the tribunal panel to hear the matter, as is indicated by the code. Thirdly, Mr. Tutobi states that the initiator, or the pro forma prosecutor, as he calls it, was me. Again, that was not the case. As already explained, I was an independent external attorney advising CSA in this matter, and it was CSA that was prosecuting him. It was a CSA investigation. I would not have been the prosecutor. Finally, he says that he was to be represented by SACA in the proceedings. He says he was going to be represented by SACA in these proceedings, and again, that's not correct. He was represented by his own attorneys in the matter. SACA were not involved in representing the players in these proceedings. Then Mr. Tutobi goes on to talk about his relationship with SACA, and he says he believes SACA treated him very unfairly. Quote, he says, SACA treated me very unfairly, and I believe it already took a position regarding whether or not I participated in match fixing even before the matter was concluded. He says, even before the matter could unfold before Judge Ngwepe, SACA had already found me guilty of match fixing. And it's slightly odd, this statement, because SACA did not play a role in the match fixing investigation itself, other than the initial role to refer players to lawyers and to pay their bills. And in fact, it was a remarkable act of compassion, in my view, that it did pay the bills of these players, even when they had pleaded guilty to various offences under the code. And I think this was beyond fair. In fact, it was generous, in my view, because it had no obligation to do so. And in fact, I suspect that if you ask certain players who are members of SACA, they might say, well, you're using SACA money now to fund the legal fees of players who have pleaded guilty to charges of misconduct under the anti-corruption code. I suspect some players may have an issue with that. But be that as it may, that is the view that SACA took. He goes on to say that SACA had, quote, already found me guilty of match fixing. And I say this is a bit nonsensical statement because SACA was not the one who was adjudicating on the matter at all. And I'm quite sure Mr. Totobi's lawyers would have advised him of that. Totobi goes on to raise argument about conflict of interest on my part. I need to address that because that's not correct either. I was only appointed to advise SACA in December 2019 after CSA had hired an in-house legal capacity and began to use other attorneys. And this investigation took place in 2015 and 2016.
You are breaking up,
Mr. Woodhouse already dealt with that incident.
You are breaking up.
I'm so sorry. Perhaps I'm speaking too fast.
Well, I don't think it's really a question of you going fast. I think maybe it's the platform, the instability of the platform you are using. For instance, I had only drips and drabs of what you were saying relevant to paragraph 249. I don't know how it can be dealt with, but yeah, if you could, at 249, you could start at 249 and give us a sense of what you want to address as relevant there too.
Okay. I was just, if I wasn't heard, perhaps I was just dealing with the point of conflict of interest there.
Yes.
In 248. In 249, I raised the point about this.
No, Mr. Becker, do you have somebody who can intervene there? Mr. Becker? Do you have somebody, or are you able to deal with
yes,
with your device in such a way that it does not become as unsteady as it is? I don't know whether our technicians here are able to talk to you and say, touch there, and we are on the same platform.
Mr. Ombudsman, perhaps I can. Perhaps what I would do is I will re-sign in, rejoin the Zoom link. Maybe that will be better. If you just give me a moment, I'll re-sign in, and hopefully that will help.
Yes, it usually assists to do that. Leave and come back.
Okay. Let me proceed.
I've been hearing you all the time. It's just that it reaches a point where you break, and then for some moments the picture, even your picture, is frozen, and then when you resume, I'm not so sure whether you resume where you broke off or whether certain things have been skipped. But I got the impression that when you resume to where you had frozen, and you start from there. It's just that it's the instability of not following you properly, because it's not your fault, certainly. But yeah, there were. Let's Let's be patient.
Yes, thank you for your patience in this regard, and let's hope you can hear me.
Yes. No, that's the important thing. You know.
I've dealt at 248 with this conflict of interest point. Hopefully you heard me on that point.
Yes.
And the next point I want to deal with is this allegation from Mr. Totobi that SACA refused to pay his legal fees. And I cite an important conversation there in my papers, Mr. Ombudsman, with his lawyer,
yes.
From a meeting I had with him on the 14th of April 2016. And I'm not going to recite the entire transcript of that meeting in the interest of time, but you will see there that on 5 occasions during that meeting with his lawyer, Mr. Van Kerkhoven, that's his lawyer's name, on 5 occasions there, I advise him to contact SACA because they would contribute to his legal fees. I make him aware of this. I say to him, I raise the point there. I say to him, the other thing I wanted to chat to you about is SACA's agreement with the players that they are contributing to their legal fees to a certain point if they cooperate. And I say, they don't know SACA. So I'm informing him, they've told me they don't know of this gentleman's appointment. So now I'm relaying the message to his lawyer that he must contact SACA to arrange for payment of his fees. And Mr. Van Kerkhoven says, and I then, during the course of that conversation, and you can see it, Mr. Ombudsman, in the transcript, the number of Mr. Bretzka, I give him his name, and I suggest on 4 occasions during that short conversation that he contacts SACA. So, and what's obvious about this conversation that I have, and I've included the full transcript of that conversation, is that I'm the one who raises the subject with his lawyer, not the other way around. I raise it with him, despite there being no obligation on me to do so. And it becomes apparent that his lawyer, Mr. Van Kerkhoven, doesn't know about the arrangement. And I actually give him Mr. Bretzka's number. And I understand from SACA, and perhaps you can ask him that today later, Mr. Van Kerkhoven, his lawyer, he never phoned Mr. Bretzka. As I understand. What is odd is when Mr. Totobi responds to Advocate Nele's question about this. Advocate Nele, about this insistence on the part of SACA to use tabacs. Advocate Nele says, who at SACA was insisting on that firm? And Mr. Totobi says, in response, obviously we were dealing with David Becker, so it was his communication between my lawyers and him. Well, they told me that they got a law firm that could assist me in this. So on the one hand, in his written affidavit, he states that SACA insisted that he used tabacs. And now in his oral evidence, he's saying it was me who communicated this to his lawyers. And I deny that allegation. I never communicated with his attorneys about who Mr. Totobi could or could not use or appoint. In fact, as you'll see from my meeting with Mr. Van Kerkhoven, it was me who suggested Mr. Van Kerkhoven actually contacts Mr. Bretzka about his contribution to the legal costs. Moving on to paragraph 252 of my affidavit, Mr. Totobi goes on to allege that he was intimidated by me. He was threatened with criminal sanctions and the laying of criminal charges in respect of a matter which had nothing to do with the match fixing investigation. And then he cites an email from his own attorney as alleged proof of this. And I just need to put that in context, that conversation with his attorney. So prior to the telephone call I had with Mr. Van Kerkhoven, and the one which he refers to on the 8th of August 2015, we had tried unsuccessfully for several months to arrange a second interview with Mr. Totobi, after we had realized that he had not been truthful to us in his first interview with us in January 2016. And after agreeing sanctions with 4 other players, each of whom had made various admissions, several relating to Mr. Totobi, I then telephoned his lawyer, Mr. Van Kerkhoven, to once again endeavor to arrange a meeting with Mr. Tsotsobi. And it's important to note that this was a without prejudice call, in as much as Mr. Van Kerkhoven had now realized his client had not been honest with him, and he asked me lots of questions. Mr. Tsotsobi's closest ally, namely his flatmate, Mr. Tsolekile, had now turned, and the game was effectively up. Hence, in that call, Mr. Van Kerkhoven asked me about some of the evidence against Mr. Tsotsobi and what these other players had relayed to him. And I told him, I was very open with him, Mr. Ombudsman, because he needed to understand, and he needed his client to understand, that the games could no longer continue. The version Mr. Tsotsobi had put to him and put to us during his first meeting was plainly false, and he needed to reconsider his position. Now, by now, Mr. Van Kerkhoven was clearly irritated with his client, and that irritation came across in our call, probably exacerbated by the fact that he'd realized that his own client had not been honest with him. And he says, noting the importance of the moment, he says, quote, "This is obviously a critical moment in the case, particularly as Tami has turned." This is the email he sends to his client. And I may well have discussed the likelihood of charges under the code, the anti-corruption code, in that call. Because Mr. Tsotsobi had been unwilling to meet for some time, and he did not appear to be cooperating. And I may also have raised the issue of a life ban under the code, given the seriousness of the offences, particularly Article 2.1.3 of the code. Mr. Tsotsobi says that this reference to a life ban was, quote, alarming. But if he read the code, he would see that under Article 2.1.3 of the code, an offence under that provision could attract a life ban. And he ended up actually admitting to that particular charge on his own volition. Then I can't recall there being any intimation. He alleges there was an intimation that somehow I was going to be charged criminally as well. But as pointed out, we didn't have the power to charge Mr. Tsotsobi criminally. And I want to refer in paragraph 256 of my affidavit to, again, this transcript of my meeting with Mr. Van Kerkhoven some 4 months before, where I spoke about the criminal sanctions. And it's very important to refer to that conversation, I believe, where, again, I raised the issue. I say to him, perhaps Louis can talk about the criminal proceedings. We haven't actively pursued that because we're too busy, I say. We haven't actively pursued that. And we go on to have a very frank discussion about the criminal proceedings. And if you look over the page, I actually say to him what the attitude was in respect of the criminal proceedings. I say, basically, I think you need to know our attitude on this generally. I say, this has taken a shitload of work, this thing, pardon my French, but by now we were exhausted after 5 months. We're into our 5th month here, but we're not really bothered with the criminal stuff. They've sat with it. They may not even have any interest in it. We don't know. And then we say, Louis Cole says, we're not pushing for that. And I say, yes, we don't have the time, energy, and inclination really to sit and run after the hawks. Louis Cole says, I don't want to go there. So clearly that reflects the attitude. It's not threatening. It's the opposite, in fact, I would say. And then importantly, halfway down that page, Mr. Ombudsman, his lawyer raises the possibility of a deal. And I respond in the following fashion. I say, well, we can't make deals on behalf of the state. That line is very important. And Mr. July, it's the type of comment that an attorney such as Mr. July would have also made in those circumstances. He would have said, listen, we can't make deals on behalf of the state. And at the bottom of the page, I then say to him what CSA's attitude on the criminal proceedings is. I say, our attitude is, and I know it's the attitude of CSA generally, is that, look, they must do their job. I'm referring to MPA here, if they need to do it. And we can't, we're not going to push that process, I say. We've got our hands full here, to be honest. We've been working on this thing every day for 5 months. So, Mr. Ombudsman, the transcript clearly shows both CSA and my attitude towards the criminal proceedings as far back as April 2016. And my submission is it can hardly be viewed as threatening. Indeed, the opposite, I say. And it's also made very clear to Mr. Van Kerkhoven in this meeting that the criminal matter was out of our hands. Now, this same attitude was then conveyed during my telephone call with Mr. Van Kerkhove 4 months later in August. And it's true that CSA was very likely to charge him under the code and very likely to push for a life ban if he was not cooperating. But his attorney needed to know that information and to pass it on to his client. And I openly relayed that information on a without prejudice basis. But there was certainly no threat of criminal proceedings as such. And as regards that alleged threat, I refer in 259 of my affidavit to the fact of when the case was reported to SAPS. That was reported by Mr. Cole on the 27th of October 2015. And then the matter was then transferred and registered in Norwood in June 2016. Now, Mr. July already noted in his proceedings the timeline there. And the question needs to be asked, why would I or Mr. Cole threaten to do something in August 2016 when A, we had already openly discussed the matter with Mr. Van Kerkhove in April 2021 in a non-threatening and matter-of-fact manner. B, I had already stated explicitly on 14 April 2021 that we can't make deals on behalf of the state. And C, that's something which I was supposedly threatening to do in August 2016 in order to reach a particular outcome had in fact already happened in October 2015. And the timeline doesn't really make sense. So moving on from that point, and I hope you can all hear me now. Hopefully I'm not breaking up too much.
No, I can hear you.
Now, moving swiftly on, Mr. Tsotsobe says that he approached SACA to ask them to assist him in an effort to obtain the services of TDR, and SACA refused, insisting on Tabak's attorneys. And Mr. Breedske will no doubt comment on this. I think Mr. Woodhouse as well. But I find it strange that SACA would refuse to contribute to Mr. Tsotsobe's legal fees when I had already effectively passed on the message from SACA inviting them, Mr. Van Kerkhove, to contact them. So I will no doubt you'll get Mr. Breedske to comment on that as well. I then move in paragraphs 262 to what I think is quite an important email from Mr. Tsotsobe's agent, Mr. Nordia. So on the 15th of March 2016, Mr. Nordia, who is Mr. Tsotsobe's agent, sends me an email. And there's a line in that email which is quite important. And I've underlined it. He says to me, Mr. Tsotsobe, he has advised us that TGR attorneys will be handling all matters effective immediately. Now, what's important about this email is he says that he has advised us, i.e. Mr. Tsotsobe has advised his own agents that TGR attorneys will be handling all matters. There's no suggestion there whatsoever that somehow SACA has interfered in that process or I've interfered in that process. It comes from his own agent. Moving on then to 264 of my affidavit. In paragraph 30 of his affidavit, Mr. Tsotsobe then says he went back home to Gqeberha and he consulted his last set of attorneys to represent him in this matter. And he goes on to make quite a concerning statement. He says the same intimidation tactics were employed by CSA and Mr. Becker on me whilst I was being represented by Mr. Dani Gous. I'm not sure what Mr. Tsotsobe is referring to here, but he provides no supporting evidence of this. And I did not receive not one single piece of correspondence from these attorneys, from Mr. Gous or his colleague, Mr. Van Schalkwyk, alleging any intimidation of any kind. Mr. Tsotsobe was very well represented. Apart from Mr. Gous and Mr. Van Schalkwyk, his agent was a qualified attorney. He also employed the services of one of the most prominent senior counsel in Gqeberha, the late Mr. Terry Price, SC. So he had 4 lawyers in his corner. And not on one single occasion did any one of these people allege that I had somehow intimidated them or coerced them. In fact, it was quite the opposite. I worked in a very cooperative manner with his attorneys. It was very professional. I found them good to deal with. They were very attentive. And Advocate Ntsebeza then asks quite pertinently asked Mr. Tsotsobe, she says, and your attorneys, did they ever escalate it to anyone else? Were some of the threats ever escalated? And Mr. Tsotsobe says, no, I don't think they did. And I think that's quite telling in 5 years that they haven't done so. If there was any basis to those allegations, one would have expected them to have written to me or Judge Ngwepe, but they haven't done so in that time. Mr. Tsotsobe then goes on to make quite a bold statement. He says that CSA and Mr. Becker executed their long-standing threats of a criminal case by opening a criminal case during the disciplinary investigation process. And he cites the case number Norwood. And as intimated by Mr. July in the proceedings, one need only review the timeline to appreciate that that's not correct. The complaint was already laid in October 2015. And I think Mr. Colt, just to some extent, dealt with the reason why he felt he was under duty to lay a complaint with the police. But Mr. Tsotsobe goes further, and he appears to suggest that it was the criminal case which compelled him to sign the sanction agreement. And I don't think that's the case at all. I think that's a false allegation. At no time during any of the negotiations around the sanction agreement did any one of Mr. Tsotsobe's 4 lawyers raise this issue as part of the sanction agreement. And in his interview on Marawa Sports Worldwide, a transcript of which has been provided to you, Mr. Tsotsobe goes as far as saying that the investigators told my lawyers to take the sanction agreement. They will not pursue criminal charges, and now I'm getting flack from the Hawks. So basically, they misled us, he says. And that's not correct. But he even goes further in his oral evidence. He says that I was told there wouldn't be any criminal case opened should we sign the sanction agreements. That's what he says in his oral evidence. But that's just not correct at all. The criminal charges, as I said, did not form part of the discussions around the sanction agreement. And even if they did form part of those discussions, which I deny, it's also inconsistent with the previous statement I had made to his attorneys on the 14th of April 2016, where I say we can't make deals on behalf of the state, quite matter-of-factly. But in addition to that, there was an entire agreement clause in the sanction agreement which said that the agreement incorporates all the terms of what has been agreed between the parties. Mr. Tsotsobe appears also to be intimating that his own legal advisors failed him, because if he was indeed intimidated or coerced or misled, then his 4 lawyers should have raised that issue with me. And in fact, they were in the same meeting where we effectively agreed the terms of the ban I think it was the 30th of June 2017. They were in that meeting. Then moving on, Mr. Tsotsobe then makes the allegation that the urgency and speed by the Becker attorneys, he's referring to me there, to conclude plea agreements and the unwillingness to proceed with disciplinary hearings and challenge the veracity of the allegations leaves much to be desired. So he's complaining, he's suggesting that the urgency and speed, almost led to sort of undue influence of some sort. And I think that's an incredibly ironic statement to make, given the significant delays we had in reaching the sanction agreement with Mr. Tsotsobe because of his failure to cooperate over several months. And I've included a timeline in the paragraphs which follow. I'm not going to go into that in any great detail, but I do wish for you to have a close look at that timeline. I'll touch upon it briefly, just to deal with this allegation of his. Because we first met with Mr. Tsotsobe in January 2016. And following that meeting, we then sent correspondence to him, his agents and his attorneys, asking for a signed statement, as we were entitled to do under the code. And we also asked for a second meeting. And you'll see in the paragraphs that follow there, we made various attempts in March.
You're frozen again.
Further evidence. And you said
you froze again.
Okay.
If you
I'll just go back a sentence or two.
Yes.
I was referring you to the correspondence in my affidavit with Mr. Totobi's attorneys, where we tried to get him to come to a meeting, tried to get him to produce a statement. And his lawyer writes to me on the 13th of April 2016, declining a further meeting and the provision of a statement. We then have follow-up with our prejudice meetings with his lawyer, not with Mr. Totobi present, because he refused to come. In April, in June, we have another follow-up meeting. I provide his lawyer with a framework of offences and sanctions. And then on the 15th of August, I'm looking at my paragraph 288. The 15th of August, Mr. Van Kerkhoven sends an email saying his client's not interested in attending a meeting, and he awaits a notice of charge. Nothing happens then in the months which follow, because Mr. Cole then decides to focus his attention on proceeding against other players who would in turn implicate Mr. Totobi. And then Mr. Totobi then appoints other lawyers in April the following year, and they then ask for extensions twice, and we give them extensions. And then we finally, at page 296 of my affidavit, sir, we finally get to the meeting on the 30th of June 2017. And that's an important meeting because that's the meeting with all his lawyers in Gqeberha, where I sit and we agree the terms of the sanction. We present a huge amount of evidence there, and effectively the agreement is concluded there. And then thereafter, there's the sanction agreement that is signed. Now, two things are obvious with this timeline and the exchange of correspondence. So, firstly, there were substantial delays in getting to the point of an agreed sanctional agreement with Mr. Totobi. Secondly, these delays were essentially caused by him. We were consistently requesting from 1 February 2016 that he provides a statement and that he attends another meeting. And CSA cannot be said to have rushed this process of reaching agreement on a sanction agreement with him, where he implies some sort of undue influence here in coming to terms with this agreement. A period of almost 18 months had passed since the first meeting in January, where it became clear Mr. Totobi was not honest with us, to the final meeting on the 30th of June. 18 months had passed, and my discussions with his attorney had lasted approximately 2.5 months. So we were very patient with Mr. Totobi. I think the timeline can see that. And it's very ironic and disingenuous for him to then say in his oral evidence, as he does, he says, I think there was also a tactic of CSA to try and drag out the matter so that we were exhausted financially. And Mr. July asked Mr. Totobi, why were you charged later than other people? And he says, to be quite honest, I don't know. But I think he does know, to be quite honest. I think he knows exactly why it took such a long time to charge him and finalize the sanction agreement. In addition, his legal fees could have been covered by SACA. So it could never have been a tactic on behalf of CSA to exhaust him financially. Next, I just want to briefly deal with this allegation of being coerced into signing this sanction agreement. There's no evidence to support this. There were 3 lawyers in the room, when we agreed the terms of the sanction. One was a very experienced senior counsel. It's just not credible evidence in my submission. But above and beyond that, Mr. Totobi admits in his own affidavit on the 15th of July 2021 in these proceedings that he, quote, reluctantly agreed to sign the sanction agreement. And he says, quote, for me, it only made sense that, you know what, just take the 8 years. The 8 years is going to go quickly. So that's inconsistent, in my view, with being coerced. Moving on then to 301 of my affidavit. So Mr. Totobi goes on to state that another flaw in the process was the fact that Judge Ngwepe was not involved in the conclusion of these agreements. And he states that categorically as a fact, but of course he wouldn't know that. In fact, Judge Ngwepe was involved in the sanction agreement conclusion in that he sent comments on the agreement by email back to me. In fact, I broke from the meeting in Gqeberha as all the parties were aware, to take instructions from both Mr. Lorgat and Judge Ngwepe on the terms, because I didn't have a mandate to just simply agree a sanction of 8 years. You'll appreciate that I had to take instructions from my client. So I broke from that meeting. Everybody heard, because I announced to everybody, listen, we need to break now because I need to take instructions from my client so we could come to an agreement. So, so I think that deals with that allegation. Then, so in 303 of my affidavit, just moving on, I deal with this allegation or this request from Mr. Tsitobi to ask for his disciplinary hearing, in inverted commas, to be reopened before Judge Ngwepe. But of course, there was no disciplinary hearing because he freely and voluntarily agreed to various offences under the code. And he then goes on to say that he wishes for his alleged involvement in fixing to be investigated. And again, I find this quite ironic because it was investigated and he pleaded guilty to various offences under the code, thereby accepting allegations. He complains about the sanction meted out to him. And
you are breaking, Mr. again.
Okay, I'll repeat myself there. Mr. Tsitobi says he complains that a sanction was meted out to him, in inverted commas. And I say CSA did not meter out a sanction to him. He was charged and he agreed to a sanction of 8 years. He complains about the 8-year sanction as not being fair. And I want to touch briefly on why we believe it was fair. I've included in RDB 26 a similar table which explains the charges that he was charged with and the potential sanctions under the code. He was charged with 10 charges under the code, including a very serious charge of contriving to fix, which he pleaded guilty to. And in RDB 27, which you can study in your own time, so we deal with the minimum potential sanctions based on his own admissions. I would stress that, based on his own admissions. And I believe that even if you do the maths, and even if you take an offence of 2.5 years for the offence under 2.4.7, you would have come to 11 years. And we agreed 8 years with Mr. Tsitobi. So I think that was a reasonable consensus. And the ICC also deemed that reasonable, as did Mr. Cole, Mr. Lorgat, Judge Ngwepe, and the 3 lawyers in the room on the day who were negotiating the sanctions. They also believed it was reasonable. And I also believe that Mr. Tsitobi agreed it was reasonable on that day. I even remember we shook hands at the end of the meeting, and he appeared satisfied with the outcome. Then, going further in his oral testimony, sir, and I won't be much longer, Mr. Tsitobi says that he believes he was targeted in a match-fixing investigation because of a petition that he and other players were involved in. He cites this petition, but that's simply not true at all because I was not even aware that there was a petition. The first I even heard of such a petition was in these proceedings. Then Mr. Tsitobi goes on to say, quote, "These guys don't understand what they did to us," close quote. And I'm sincerely sorry that Mr. Tsitobi and his colleagues have had to endure the hardship of these bans. This would not have been easy. I can accept that. It was very unpleasant for me too, being a cricket fan in particular. And this whole episode has been very unfortunate. But this is classic victim mentality. Note carefully the words he's using here. He says, what they did to us, what they did to us. And then he goes on to say, in his transcript on page 66, he says, "I've lost my livelihood and there's reputational damage that was done by Cricket South Africa." And I say, well, that was reputational damage that unfortunately he did to himself. It wasn't Cricket South Africa that did that reputational damage to him. He seems to blame everybody but himself, unfortunately, and he's even made insinuations against his own lawyers by suggesting indirectly that they didn't do a proper job. because they sat in that room when we agreed those sanctions. Then I must just deal at 312 of my affidavit with these allegations from Mr. Toby about not getting any evidence. He says, we didn't get any evidence of the situation. My lawyer asked them to give us the proof or to give us the evidence they've got towards me. He says, we never got anything. We would go to a tribunal. We never went to a tribunal. Now, Mr. Totobi, hopefully you can still hear me.
Yes, yes.
Are you with me, Mr. Ombudsman?
Yes, I am.
Okay. Mr. Totobi wants this office, he wants the Office of the Ombudsman to believe that he pleaded guilty to 10 charges under the code after a meeting lasting several hours with his 3 lawyers without having any evidence presented against him. It's just not credible, unfortunately. Extensive evidence was presented in his 2 without prejudice meetings with Mr. Van Kerkhoven and then in the meeting in Gqeberha with his lawyers. And to then state that we were promised that we would go to a tribunal is just disingenuous, because we never gave him that promise. He could have gone to tribunal if he wanted to, and certainly his legal team would have given him that advice. And in fact, he alludes to that at page 55 of his transcript, where he talks about Mr. Price, his advocate. And he says the way Mr. Price put it to me was that if I let this thing carry on, they were thinking of giving me a life ban. So I would.
You are breaking again, Mr. Mr. Becker, you are breaking again. I don't know.
I'll just refer you.
Maybe you should speak into the mic or something. I don't know. Every time you, in fact, you do not, you move away and not address, and not appearing to be looking at me, then I lose you. I don't know how it can be remedied. But most of what you were saying, I heard. Yeah. Yes. When once you do that, when once you look to your side like that, then I suppose you are reading from somewhere, and it is not in front of you or behind the mic. I don't know if you would be able to do that anyway. Then the difficulties start there. You are frozen even now.
Yes, I think I'm going to conclude my evidence now, Mr. Ombudsman. I'll probably be 5 or 10 minutes.
Yes, but there are questions that you will be asked.
Yes.
Yes.
Okay.
Yeah.
And I think if I start glitching again, I will re-sign back in again, and maybe that would help. Mr. Totobi also intimates that his sanction agreement was not countersigned by CSA and it's therefore void. But you'll be in possession of all the signed agreements now, I believe. And Mr. Law, and it really pains me to say this, sir, that it is evident that Mr. Totobi's evidence, both written and oral, it's intertrue. It's simply readable. To finish now.
No, I didn't get that at all.
With 2 points.
Mr. Becker, I didn't get that at all. And it looks like it was a very important submission that we're making.
He was reading 315.
Yeah.
Was it paragraph 315? You were reading into the record, paragraph 315?
That's correct. I made a point about the co-signing of the sanction agreement, which hopefully you heard. And then I go on to conclude. That it's evident from Mr. Zitobi's evidence, both written and oral,
yes,
that his evidence is littered with irrational and inconsistent statements and interspersed with untruths. And my submission is it cannot be relied upon as being credible. And I would just like to deal very quickly with two additional points, which you've asked me to comment on. This first one, the conflict of interest point. People in these proceedings and in the media have alleged that I have a conflict of interest, and you've asked me to deal with this point. I'm not sure that it falls directly in the terms of reference, but nevertheless, I would like to comment on it because certain people have tweeted about it as well, Dr. Eugenia, certain journalists. I would like to address it. It seems to me that these allegations are based on a misunderstanding of A, the timeline of proceedings, and B, the role of an attorney in private practice. And as previously explained, sir, I was the legal advisor to Cricket South Africa from 2013 to about midway, and to some extent until the end of December 2019. Now, this match-fixing investigation took place in 2015 to 2016. And I was only appointed by SACA in December 2019. In any event, SACA was not involved in advising any of the players in the match-fixing investigation. And I also, you may have heard, advised Mr. Smith personally on his contracts with CSA in 2019 and 2020. However, he was not a member of SACA either, having retired from cricket in March 2014. So from time to time, as an attorney specializing in sport and in particular in cricket, I do work for different members of the cricketing family where there is no direct conflict of interest. And the rules of the Law Society permit me to do this as long as there's no direct conflict. And as a matter of good practice, I always raise this with my clients concerned and to ensure that they are comfortable. And in the 25 years I've been in practice, I've never had one client complain that I've had a conflict of interest, and I've never had any complaint to the Law Society from anybody that I've been conflicted. So hopefully that would just clarify that, and I hope that you heard my submissions on that point on conflict. And I'm going to look directly at the camera now, so hopefully that will help. Just in closing, you'll see I dealt somewhat with this jurisdiction point. I'm not going to dwell on that point in any great detail, but I do wish for the Ombudsman to appreciate the view that we've taken in this matter is not to take technical points. We've come here and we've discussed this. I discussed it with Judge Ngwepe and with senior counsel. Our view was that to simply say, to question, the issue of jurisdiction would not have been helpful to the Ombudsman. It would not have been helpful to the media, to the public, to the players themselves, to simply hide behind that. We've come here, we've been transparent. I've given you a very detailed affidavit. And just as we were meticulous, thorough, and integrous in our investigation, we've been meticulous, thorough, and integrous in responding to these allegations. And my hope is that the learned Ombudsman will appreciate this cooperative approach. Mr. Ombudsman, in conclusion, it's very unfortunate, I feel, that this investigation, which was praised by the ICC for its processes and outcome, has been tarnished due to the opportunistic claims of a few people. I find that very disappointing. As an independent third party, you having agreed to assist to fight cricket against the scourge of match fixing, it's very disappointing to find myself in a position where I have to defend allegations that have no merit. I remember very well where that call came in. When the call comes from the boss of Cricket South Africa to ask for help in a dire time, I put up my hand to try and help in very difficult circumstances. So I find this very disappointing that I have to come here and answer these allegations. However, I am a positive person, and I really hope that something good comes out of this process. In that regard, perhaps my final point, if I may touch upon reconciliation, because I know that is a matter that is very close to your heart, sir, and to the hearts of Advocate Mele and Mr. July. I'm not actually a litigation lawyer. You'll be surprised to know I'm a commercial lawyer. I like to bring parties together for a positive outcome. So I am also interested in reconciliation, and I'm going to speak from the heart here. Just in closing, I think you will appreciate that it is quite difficult to think about reconciliation when in the light of some quite far-reaching allegations, particularly where those allegations are not correct or not founded, and particularly where those allegations are made in the media and covered extensively. However, I have thought about reconciliation in the context of the match fixing. And I would say this, sir, it is my sincere hope that these four individuals would take a leaf out of Phumi Machikwe's book. And I'd like to reflect on that for a second. Phumi Machikwe, yes, he wasn't honest with us in the beginning. He made serious mistakes, but he put up his hand. He stuck up his hand, he came clean, and he was sincere, he was remorseful, he was genuine, he was authentic. He didn't come with false allegations of coercion and threats 5 years later. And if I had to see Phumi Machikwe in the street today, I would actually go up to him and I would applaud him, because he's redeemed himself. He's tried to make something positive of the situation. He's got involved in education. You saw him in the video that Mr. Cole played, and he's restored his reputation somewhat. I'm actually admire him for doing that, and I implore your good office, sir. I implore you, sir, to perhaps speak to these individuals and refer them to Phumi Machikwe, so that they might also redeem themselves and restore their reputation. So that's, thank you very much for bearing with me with my submissions, which I appreciate were long and detailed. And I want to thank you for your time, and I apologize for the technical glitches. And I certainly am here to answer any questions that you might have.
Yes, thank you very much, Mr. Becker. I only hope that questions which will be put to you will not be regarded by you as cross-examination, because indeed we had not provided for cross-examination in our terms of reference. Though, where there may be factual disputes about certain aspects of the evidence that is put before me, and those aspects cannot be resolved without cross-examination. As I repeat again, the terms of reference make it so, make that provision very clearly, that where there is a factual dispute that cannot be resolved without cross-examination, I shall, in my sole discretion, either allow cross-examination or record the factual dispute without resolving it. But subject to that, the decision to allow cross-examination of parties who appear before me will be at my sole discretion as ombudsperson. So I wouldn't like to get to a point where people should feel that they're being cross-examined when my legal resource, for instance, in the form of Mr. July, puts questions that I would have put when my legal advisor, Advocate Mele, put questions that I would have put. It is only to the extent that there may be a factual dispute that needs to be resolved. And even so, I would like an attitude to be taken by everybody that it is just questioning for clarification of the facts. Mr. July?
Thank you, Chairperson. Mr. Baker, I think yesterday you commented that the questions that were asked to you were fair questions and you did not in any way view those questions as being cross-examination. And in any event, whatever question that I ask, it's not whether it comes across as a cross-examination, it's intended to help this process. So bear with me if I were to ask you a question that comes across as if I'm cross-examining you, but that is not the intention. Now, you'd recall you testified about, you gave the sequence, and Mr. Cole as well, about the meetings that Mr. Peterson had with one on the 5th of October with Zolekile, the other one was on the 10th with Bodie, and on the 8th, when he met with on the 8th with Mr. Irish, Tony Irish, he told Tony Irish about the event or about the meeting of the 5th of October that he had with Zolekile, and that there is a match fixing that is taking place there. And then on the 12th of October, in a meeting with Mr. Cole, he then relayed, and of course, according to Mr. Cole and you, he did not disclose the full account of what happened on the 5th of October and also what happened on the 10th of October, right? But this is what I want to find out from you. When Mr. Tony Irish says to Mr. Peterson, when you deal with Mr. Bodie, treat him normally. When you respond normally, meaning that after the meeting of the 12th, you are still allowed to talk to Mr. Bodie. Don't give the impression that you have reported this issue. Are you aware of that conversation?
Mr. July, yes, firstly, just to respond to your opening point, I'm happy to take questions of clarification. Yes, just to deal with the first point. Second point, you're asking me about meetings that I wasn't present at. You're aware of that. So it's difficult for me to now give evidence under oath of what happened at those meetings. I mean, I've seen potential transcript, but you will appreciate you're now asking me under oath to comment on meetings that I wasn't present at.
Okay. In paragraph 10 of his affidavit, which is in your possession, Mr. Peterson makes that point. Neither you nor Mr. Cole are responding. As you correctly pointed out, you should not have responded. You can't respond on that issue because you were not part of that meeting. He says, Louis Cole and Tony Irish were aware or ought to have been aware that I had communication with some of the players involved, as Louis Cole asked me to interact with a teammate of mine, and two, Tony Irish advised me to act like normal with Bodie so that he would not suspect that I might have reported him. Furthermore, I have mentioned on many occasions, including to Tony Irish, Louis Cole, and NPA, that I was anxious about the safety of me and my family. If it must be known that I came forward with the match-fixing information. I will elaborate on this if need be. So I'm raising this issue because one of the issues that you take about him is the fact that he met, and even according to you, proactively met with Mr. Bodi. And he says, I had to do that. I should not have given these guys the impression that I've reported them. I had to meet with them as if things are normal.
What is the question then to Mr.
I'm asking, were you aware of that conversation? Or was it brought to your attention by Mr. Cole?
I think the question you should have asked that of was Mr. Cole and Mr. Irish, and because they were the ones who were present at that meeting, not me. And I think Mr. Cole, in his affidavit, may well have referred to the instructions or the content of those conversations, with Mr. Peterson at that meeting. It's difficult for me to comment on that. I'm not trying to dodge the question, but you're asking me now to say under oath report about a meeting I wasn't even present at. So I don't know how I can help really on that.
Okay. Mr.
Other than perhaps Mr. July, to ask Mr. Cole again or to give him an account of those meetings. I think there were parts of those meetings he recorded. So I think, if needs be, you just look at the transcripts of those.
I went through the affidavit of Mr. Cole, and this particular issue was not addressed, this paragraph 10. And as you would recall, I could not ask certain questions to Mr. Cole because any question that I would have asked to Mr. Cole, which has nothing to do with the discrimination, was viewed as cross-examination. So it was not in my place to ask him those questions. But I accept your point that you were not part of that meeting. And as I understand, you were not informed either by Mr. Cole about this conversation.
My understanding was, and I only got this from Mr. Cole, was that he advised Mr. Peterson not to do anything further with Mr. Bodi, to be on his guard, not to do anything further. That's my understanding, but that was just relayed to me by Mr. Cole. So,
He deals with that part where Mr. Cole, in his affidavit again, where he says all what Mr. Cole said was don't tell, which is a different issue. Don't tell. Nowhere does he say don't communicate. Don't tell him about this investigation.
Okay. I think you'll have to ask Mr. Cole about that.
Okay. Now, yesterday, Mr. Cole, when I asked him, I'll give you a context. I asked him about the 23 players. How were they investigated, how they were asked questions, and you also confirmed that indeed all those players were subjected to the same method of investigation. They were asked questions. So I asked this question to Mr. Cole. In you not finding or in coming to the conclusion that these 23 players were not guilty, how did you go about it? Right? Can I give you what was his response? He says, basically, Mr. Ombuds, as each of the players was mentioned by Mr. Peterson, Mr. Bodi or Mr. Tsolekile, I dealt with each one. So if it was a national player, but the name of X, I would look at the evidence and then interview Mr. Bodi about what the involvement was. I would go through the WhatsApps and I would go through Mr. Bodi's telephone record to see if there was any interaction. The police had assisted me with what we call spider webs, which connected the various telephone conversations between Body and certain players, and those names never came up. Or if they came up, it did not match up with the evidence we had that they had ever been approached in that regard. That is the specific answer that he gives. Now I want to ask you, and also in his answering affidavit, in paragraph 143, when he talks about reviewing or looking at Mr. Mbalati's cell phones, he makes mention of assessing cell phone, and also, maybe I should read that, I don't have it in front of me, but having listened to the conversation between Mr. Mbalati and somebody else. So the question that I want to ask you, who authorized the interception of the cell phones of these players?
Yeah, it's a fair question. With regards to that specific question, because you made a few statements there of who authorized the cell phones. So under the code, you'll see the code makes provision for the collection of evidence from individuals, from participants, and it entitled us as investigators to ask for this information, and we did. We filed a letter of request for this information, and these players willingly handed over their phones.
Yes.
Willingly. And I should emphasize that. But what they did before, many of them did before they handed over the phone, was to wipe them clean. But fortunately, due to the diligence of SJN, the forensic team, we were able to recover thousands of WhatsApp messages from these phones. And I can tell you now categorically, without SJN, without the digital forensics, we would have really struggled, because it provided important corroborative information. So the short answer, Mr. July, is they willingly handed over these phones.
Yeah, but that's not the answer to the question. I hear that part where they hand it over, and then you take them and do the mirror imaging of the phones. I'm talking about being assisted by the police, the spider's web, which connected various telephone conversations between Body and certain players. How did the police assisted you in this regard, in terms of the spider's web, and who authorized that interception of conversation between Body and certain players? I'm not talking about the mirror imaging of these cell phones.
Yes, when he's talking about the SWAT, I mean, you should have asked this question of Mr. Cole, not me. But in any event, I do know the answer, I believe, and perhaps I can help you on that. The spider's web he's referring to, I think, is also information that he may have got from the police about particularly cell phone tracking. I think that he might have got assistance from the police on the cell phone tracking in particular, where certain individuals are. I was certainly not aware of the police being involved in any recordings of any conversations. I've got no information on any of that. I'm not aware of that. Sorry, Mr. July?
So, sorry about that. I was asking for Mr. to assist me because I've realized that I left Mr. Cole's affidavit. I want to take you to the paragraph where that paragraph 143.
When Mr. Cole got assistance from the police was in respect of cell phone tracking.
Okay.
You'll have to ask him, but that's my understanding of it. He produced that spider's web. And I think that's what he's referring to. I'm not aware, there were no recordings of telephone calls that we received through the police's assistance. We studied the WhatsApps meticulously because they were revealing.
Okay.
Hopefully that helps you somewhat.
Yeah. No, that's fine. Now, you came here, and the main reason why you came here is to respond to the allegations of racism that have been made against you. And you have every right to do that. Now, I want to ask you a specific question as a person, not specific, sorry, a generic question, as a person who has been involved in cricket for such a long time, and with particular reference to South Africa.
With particular reference to what,
to
sorry?
South Africa.
Oh.
Yes. Would you say there is no, two questions, racism in cricket in South Africa? Two, the transformation. Is the transformation agenda being achieved in cricket South Africa?
Mr. July, are you seeking him to give you a factual basis?
His view.
For those views? For the view on whether there is racism or not?
Yes, yes. I'm asking your view whether your view about racism in cricket, because you have been involved in this, whether does it exist or it does not exist?
Those are very broad questions, and I could speak for a long time about those questions.
I think I need to restrict any questions for clarification to a resolution of a factual dispute that may have arisen in the giving of the evidence by Mr. Becker.
Mr. July, I would love to answer those questions. Perhaps we can go afterwards, but I think it's probably not the appropriate time or the environment to do that. It's given that they have no direct relevance to my evidence. But it's a pity, because I would dearly love to answer them, and it's probably.
If you are happy to answer the question that Mr. July put to you, I have no problem. But I don't want you later on to say, that ombudsperson, when he had even referred me to where cross-examination can be allowed at his sole discretion. Now, he allows Mr. July, to cross-examine me, even within the limits of when he is permitted by his terms of reference to allow questions. So, I mean, the short view I take is, if you feel you want to respond to Mr. July's question in an endeavor to help me, because I always want people to understand that this is not an adversarial process. It's a process in which all of us are trying to address what has been identified by Cricket South Africa as an issue within Cricket South Africa. And the inquiry is for me as ombudsperson to establish whether, in fact, there was an impact on the cricketing sport as a consequence of racism, as a consequence of gender bias, and to what extent it was, and then all the other things that we talked about, including your passion for a need for reconciliation. All those will come as a consequence of a dialogue, because this is what I would like it to be, a dialogue between all of us in an endeavor to address specific issues of race and gender, which have been highlighted in the terms of reference. So to that extent, if you want to venture a response, you can do so, without saying, hey, he's now, throwing me to the wolves. And Mr. July is having
I don't want to not answer these important questions, but it could be a long answer, and I know Mr. Britske is probably waiting to come on. I would just say this, in response to the first question, do I think there's racism in South African cricket? I've been very involved in South African cricket since, well, in cricket, as you know, but specifically South African cricket since about 2013. I've had the privilege of working quite closely with the team. I've even attended, 2 or 3 of the culture camps, and I must say, if I had to say one thing, those culture camps were very, very memorable experiences for me. I cannot tell you just how important the work that was done in those culture camps for everybody. And as Dr. Musaji said, those culture camps were almost like a mini SJN. And he was at the forefront of that, him and Mr. Smith, together with other senior members of the team. And I would really encourage the Ombudsman to read a book which I'm going to send to you, the book Belonging, called Belonging by Owen Eastwood, where he talks about the impact of those culture camps. So whilst I certainly haven't experienced personally myself where I've seen blatant racism in South African cricket, what I will say is that those culture camps, for me, are the answer. They provided tremendous momentum towards understanding one another, really, in what was an informal, non-threatening, constructive, empowering environment. And my advice to CSA is that they need to do more of those, and they need to be more regular, because the value of those culture camps, particularly with a view to moving forward as a country, to understanding one another better, those were invaluable. So that's my comment on that. I fully understand the importance of the transformation agenda in South African cricket. I think there's been some important comments on it in these proceedings. One of the things which stands out for me is that, in particular, as regards transformation, we need to produce more players of color, particularly African players, coming through the system, and something is preventing that from happening. What is that? Particularly Black African batters. It would be wonderful if we could see more Black African batters. We know that talent is there, and I think part of the issue is access, because as I think Mr. Manak said, Black African bowlers, it's much more accessible to become a bowler. With the batters, you now got to get kit, you've got to get equipment, you've got to go have availability of a net. There seems to be an issue there, that if we can address that issue and we can get more accessibility for young Black African batters, I think that would go some distance towards even more transformed team. So those are 2 very brief comments, snapshots, if you like, in response to those questions, because they are very big topics that you've asked me to comment on there, Mr. July. So I'm very happy to comment on them, but I think we're going to be too pressed for time in this particular context.
Thank you very much, Mr. Becker.
Thank you, sir, and best of luck with the remainder of this process. I know it hasn't been easy, and you're under some severe time constraints. So I appreciate your time very much, and thank you for the opportunity to address you.
Yes, yeah. No, we're trying our best, and as I say, I would like everyone to regard this process as non-adversarial. Questions by me, assisted as I am by the 2 who are assisting me, are intended to find ways that address an issue which Cricket South Africa itself identified for investigation, hence the appointment of the Office of the Transformation Ombudsman. At least I haven't asked you to take the knee, but then there you are.
Thank you, Mr. Ombudsman. Thank you, Mr. July, Advocate Nele. Thank you.
We will adjourn for 10 minutes, and so that we begin to hear the next evidence will be from SACA, South African Cricket Association. That will be at 11:45. 11:45. We are adjourned. Right, we are ready now. How do we pronounce your surname?
Britsky.
Britsky.
That's it.
Okay. And your first name is Andrew.
That's it.
Andrew Charles Britsky. Right. Okay. You know, people are sensitive with their names, you know. I suppose I also am sensitive. When people call me and say, Benzo, then I say, no, that's not me.
My name has very many pronunciations, so.
Okay, yes. Do you mind taking the oath, or are
Not
you
at all.
going to? Oh, yeah. Mr. Andrew Charles Britsky, do you swear that the evidence that you are going to give in this proceeding is the truth, the whole truth, and nothing else but the truth? And if that is so, please raise your right hand and say, so help me God.
So help me God.
Yes. Just from a time perspective, I've been informed that when is your flight back to Cape Town?
8 o'clock this evening.
So what I was proposing we should do, we are now at 12:05. If we could run until 1:30, and then take a short lunch break to 2 o'clock and resume at 2, and then we go as far as we can.
Happy.
Yes.
Happy.
Okay, yes. Mr. Britsky, you have been sworn in. I see your tomb, quite a number of paragraphs. And as I've been saying to everybody here, and for my sins, I was crucified for that. You can give your evidence anywhere, any way you want to give it. You obviously are going to be guided by your affidavit, and you will probably want to follow your affidavit as best you can. But if you are able to take it in chunks and say, I'll address what is in paragraph so and so, this is the theme there, and but I don't want you to feel that there are stones that you left unturned because I said, I've seen your affidavit. So feel free to refer to your affidavit, feel free to deal with certain aspects or paragraphs of your affidavit as fully as you feel the essence of what you are going to be responding to is conveyed if you go to those paragraphs in full. What I wouldn't like you to go away feeling is the fact that you were not able to answer fully to allegations that have been made against your organization simply because you were restricted as to what you should do. On that basis, the floor is yours, Mr. Britsky.
Thank you, Mr. Ombudsman. Just by way of introduction, we Cape Townians, so we flew up yesterday evening, brought the cold weather with us, and I'm here with my colleague, Mr. Brigitte Wachipa. He's the head of legal at SACA.
Okay.
And that's an important starting point for us because we don't have attorneys here. We're not represented. I've drafted these papers myself. And I'm an admitted attorney. That's my background as well. Being a law graduate, and I practiced in employment law for a number of years before meandering into sports law, as one tends to do. I also happen to be chair of SAID's anti-doping tribunals. I'm an associate at the Institute for Development Labour Law at UCT, so I'm still quite involved in the labour law side of things. But I sit before you today, obviously as an executive member of SACA and as the CEO of the South African Cricketers Association Management Company. I mentioned we're here in person, and that is important because we regard this process as important. I believe that one can get into a dialogue probably easier in person and even outside this room rather than on a Teams call. At the same time, and I will raise it a bit later, there are a few things that I'd like to impart to you, which I wouldn't want to do in public. Just a few facts that I'd like to just mention in private, which I think is better done in person as well. So we're here to assist in this process. From the outset of this process, starting the SJN, probably it's over 12 months now, we voiced our support of the process, and that's why we're here. And we've obviously listened to the affidavits, listened to the submissions rather, we've read the affidavits and the transcripts as best we can. Difficult to be totally comprehensive in that regard. And this affidavit attempts to respond to all of those. There might be repetition. I might leave something out somewhere. That's not intentional. I really want to actually get to the bottom of a number of statements that were made, sadly a number of false facts that were put out, but also a greater understanding for yourself of the cricket landscape and where we are, and issues around transformation, which are in the headlines every day in South African cricket and South African sport. There is no place for racism or discrimination in our sport, and that's a position that SACA fully supports and takes forward to our members. And we've all got to do what we can do to make sure our sport transforms. SACA consistently says it. Cricket must reflect ultimately the demographic of our country. And we will touch on a number of challenges and obstacles that are there that I believe and I hope that the SJN will also address. The affidavit has also been drafted in response to some questions that were forwarded to SACA from your office, and I deal with them near the end. There were subsequent questions which were sent us after I'd actually completed 90% of the drafting, so I haven't included them, but I will, in presenting, deal with a number of those questions as they come up, and as I deal with issues related to that. So I hopefully will cover a number of those questions as well. Yeah. I'm also obviously happy, and I said it to Advocate Mele, to respond in writing on other certain questions that you might want to put forward to us. Yes. With reference to your point of how one sets this out, obviously that's a challenge when one sits down and drafts something, just as it will be a challenge for you when you sit down and draft your findings. But our response really fits under 5 key headings, which I want to go into and deal with each one and move through like that. The first being understanding specific issues around the cricket landscape and cricket imperatives that I don't think have been raised yet at the SJN, which is why it's important. Some supplementary information, which is on top of what we submitted back in, I think it was June, on SACA, on understanding the business of the Players Association. The third is our response to specific narratives that have been heard here. And by narratives, I say it's not one specific individual. It sort of comes from 3 or 4 individuals. I've pulled them together, and I've tried to give a brief response to that. Then response to individual submissions, and then also a response to some of the questions sent through in May, which I will deal with and which I'll probably touch on actually while I'm going through my initial points. So if I could start, Mr. Chair, and looking at my first port of call, which is the understanding of the cricket landscape and cricket imperatives, which I do believe is critical for one to understand where transformation fits into the program of cricket in South Africa and issues around resources. It is critical because the allocation of resources, the funding of teams, the funding of transformation, the pipeline, the player opportunities is critical to what you've discussed over the last number of months. And some of the things I'm talking about now, I think CSA should raise them, might raise them, but be that as it may, I'm going to raise them because there are issues we deal with almost on a daily basis. I do believe it would have been useful for the SJN if up front there'd been some preliminary submissions from previous CEOs and CFOs of CSA. It would have helped you just to understand what is an incredibly complex professional sport model. I think when Professor Fall was testifying, you actually even made the comment, wow, this is complicated. And it is.
Very complicated.
It's not straightforward. But hopefully the union will help you, sir, and we will provide you with clarity and guidance. You can always trust the union. Yeah. Anyway. my point 9 is a paragraph that is very important. It's very important because I don't think it's been said, and I'm going to read through it slowly because I think it needs to be understood. The cricket career path of any player is complex, and it's critical to understand how the career development path of bowlers and batters, because that career path is different in itself. And it would have been useful if maybe some coaches had come in and explained that as well, because the brutality, the absolute brutality of professional cricket and professional sport in general is that either the player retires from cricket on his or her own terms, or someone else retires the player. And often that's a CEO, a selector, or a coach. The catalyst for this may be the emergence of a young new talent, the performances of a teammate, a loss of form, or merely the decision of a new coach to come in and restructure a team. Totally outside the control of the player. In these cases, the player is often not ready to retire because he or she believes they still have more to offer the game as a professional. And this can lead to frustration or unhappiness on the part of the player, and is actually why our SACA dual career and transition program is so important to us, because it's about how a player exits the game, how he or she has an alternative career. It's important to remember that there are only 17 Proteas men's contracts, there are only 14 Proteas women contracts, and there are only 205 provincial contracts. That's about 230 contracted cricketers in South Africa. That's not a lot, significantly less than rugby, and it's even more significantly less than football. And that is relative to the hundreds and hundreds of players striving to secure one of those contracts. If you are the number 3 batsman in the Proteas team, on any given day, there are a number of players who have one objective in life, and that's to get you out your position, because they want that position. The competition is exceptionally fierce. There is no other career which is as competitive and fragile as that of a professional sports person. And in cricket, that competitiveness and fragility is elevated by the fact that the measurement of performance, have you done well, is based on individual performance within a team context. You and I can watch a football match, and I can say, gee whiz, I think player number 10 had a decent game. And you might say, geez, I don't think he had a decent game. If a batsman goes out for 0, there's no debate. He didn't have a good game. It's brutal. It's fragile. And if you listen to a number of the testimonies that you've heard, and we hear them often from players in our dealing with players, we do exit interviews for every single player that leaves. This is at the core of that feeling of, I don't think I'm ready to leave the game yet. And that unhappiness sometimes can translate into bitterness. I think that's the reality. But it's also part of the work we have to do to make sure that players exit the game on their own terms and not forced out of a game because of decisions of coaches. And I think that's a really important starting point to understand the landscape of how tough it is to be a professional sportsman, but even more particularly a professional cricketer. And I think it's the basis of many of the discussions around players and their careers. Mr. Linda Zondi actually mentioned in his testimony, I think he was referencing Mr. Tommy Tsolekile, and he said they were considering Mr. Tsolekile, but at the same time, Mr. Quinton de Kock was coming into the team, and he was an incredibly strong player, young player. It's exactly what's happening in that scenario I've just painted. New player coming in. And you don't know when that's going to happen. You can have a good season, but actually there's a new superstar that's come through. At the same time, there could be a player who's the best player in the world and who stays in the team for 10 years, for 15 years. And that takes away your opportunity as a player. So it is brutal. And I think it goes to a lot of the sometimes anger that we feel from players and that we deal with players. Moving on, Mr. Chair, another important landscape point I mentioned there in 10 is that the Proteas men's team accounts for more than 80% of the revenue generated by Cricket South Africa over any given period. And that comes from primarily broadcast revenue, sponsorship revenue, and ICC revenues. Almost on a 50-25-25 basis. Broadcast revenues are the biggest source of revenue for Cricket South Africa, and it relates to broadcasting of the Proteas men's game. I think Professor Fall mentioned that in his subsidy. And that negotiation for broadcast revenues is probably Cricket South Africa's greatest angst in any given period, is to get that right. Sponsorship revenues sadly have reduced significantly over the last 18 months, and COVID has played a role, but from the union's point of view, we know that a lot of that's got to do with the governance and operational crises that have engulfed Cricket South Africa. And ICC revenues, they fluctuate depending on politics of the ICC and obviously the dollar-rand exchange rate. If the rand is weak, ironically, cricket does well because about 60-70% of that broadcast revenue is actually dollar-based. And why is that so important? It's because as a business model, cricket is slightly flawed. You've got one asset, the Proteas men, that funds everything else in cricket. It's a pyramid, flow down, trickle down scenario. Transformation, pipeline, age group cricket, development cricket is actually funded through the success and the performance of one team. That's not necessarily a sound business model, but it's what it is in professional sport. Very similar, but not the same for the Springbok rugby team, although their franchises also generate money. But in cricket, we only have one entity that generates revenue, and that's the Proteas men. Within that context, it's important to understand how CSA budgets. Traditionally, they budget over 4 years, and that's to make sure that that budget actually reflects or mirrors the Future Tours program. Because you want in every 4 years, you want to have a home India series. A home India series is where you generate your revenue. You may have 3 loss-making years and 1 profit-making year, CSA, and that profit-making year is when India tour. India are touring here at the end of the year, critically important year for cricket in South Africa, not just on the field, but financially. That is critical. If India decide not to play one match, it can be worth 50, 100 million rand to Cricket South Africa revenues.
How is that so? What is the magic there?
The magic is purely that if I heard a statistic, I must remember I'm under oath, so I'm not sure if it's an accurate statistic, but if you have a ODI, a one-day international cricket match at Newlands in Cape Town, you'll probably find there's 7.5 million South Africans watching that live on TV, maybe 10 million. If you're playing against India, that being broadcast into India will be hundreds and hundreds of millions of Indian people.
Even if you play it here.
It has to be played here.
Yes.
It's on your home series that you get the revenue. We don't get that revenue if we play in India.
Okay.
India get that revenue. And that's why India is so powerful.
So you say the revenue generated by the watching crowds in India, that revenue comes to you?
Yeah, from the broadcaster.
Okay.
Because the broadcaster strikes a deal to broadcast it into India. Star Sports is the company. And obviously through advertising revenue, just through hundreds and hundreds of millions of people who are absolutely mad about cricket in India, that generates the revenue. Okay. Which is why India are so powerful in world cricket.
And Pakistan?
Not as powerful, not nearly as powerful. The IPL, the Indian Premier League, which I'll touch on a bit later, their broadcast revenue deal, I'm not sure if it's over 4 or 8 years, I think it's 8 years, is $4.5 billion US. That is bigger than all the other countries' broadcast deals put together just about. It's phenomenal, the power of Indian cricket. That isn't healthy. It's not healthy to have one country who is so strong relative to the other countries. Because it can...
Because of the population?
It's the population. Our cricketers in South Africa are bigger superstars in India than they are in South Africa. And it's just the number of people that follow cricket in India. It's quite an experience to go there, apparently, and experience cricket there. And it's why India has got muscle. It's no coincidence, Mr. Chair, that when COVID struck last year, the World T20 was to be played in November last year, but it was postponed. They played an IPL instead. And then they played an IPL in March, and they postponed it because of COVID, and they finished it off in September. So we had 2 full IPL tournaments under COVID before we had a World T20 tournament. That's because India, when India speaks, everybody sits up and says, okay. And whether we like it or not, that's a reality Cricket South Africa have to sit with in terms of their relationships at international level. And this year is critical to South African cricket because India are coming at the end of the year. And one T20 is worth millions and millions of rand to us. So it's critical that we have COVID under control, that we don't have a problem with COVID, that the bubbles work, and that India are here. when Australia pulled and England pulled from their series in South Africa in March last year, that cost Cricket South Africa about 150 million rand. Because those are also lucrative tours. But having said that, not as lucrative as India. So CSA, as I say, constantly has to balance this FTP, Future Tours Program, as it's called, to make sure it's profitable. And sadly, CSA's reputation over the last 2-3 years at ICC level has not been good. And that's where a lot of that politicking happens. So that's a challenge for Cricket South Africa. I mentioned here in 11.3 the expansion of the Indian Premier League. They've now gone from 8 teams to 10 teams. And the fact that we're going to have an ICC event every year for the next 8 years means that the calendar to play bilateral cricket against other countries, has shrunk to about 7 months of the year. So it's only 7 months of the year that Cricket South Africa can make money in that regard. And if that ICC event is in our summer, like it is currently now, and it will be next year, that goes down to about 6 months, which is challenging for Cricket South Africa, because how do we play cricket and make money when the IPL is taking so much time and all players are released for the IPL? I believe in future we'll start seeing cricket being played in August in South Africa, just because we've got to try and find time to play cricket. You won't play it in Cape Town, obviously, but you'll play it up here on a dry field. So it's really challenging when you look at the financial landscape of cricket in the world. The challenge for CSA, for FICA, the International Cricketers Association, for the ICC, for SACA, is how do you balance all these T20 events around the world, the IPL, the Big Bash, with bilateral cricket. The top South African cricketers today who specialize in T20 can retire from playing cricket in South Africa and earn more money just playing events around the world. That's not a healthy position for us to be in. FICA has done studies with players around the world, and whereas 10 years ago every player's aspirational goal was to play Test cricket for their country, that aspirational goal is no longer 100% of players. About 50% of players is, I want an IPL contract. Chris Morris, South African player, has got an IPL contract, public knowledge, worth 32 million rand for a season. That's more than all the Proteas earning together. Just giving you the scales of the economics that we deal with in cricket. So it is challenging. So I go on in 12, in addition to obvious things like strong and ethical leadership we need at cricket in South Africa, for South Africa to thrive, not merely survive. Cricket in South Africa over the last 3-4 years has just survived. We've been treading water. If we're lucky, we've been drowning at times. And we need cricket in South Africa to thrive, to achieve the objectives we want. They are... You were referring to the financial... The issues at board, because they're all related, and that's the challenge we have here. There's nothing acts independently. Transformation requires a massive financial. So when there's a challenge at board, with a challenge with sponsorship, that reflects down, and that's been our challenge. On every front we've been battling. It's not like a Springbok rugby team who Springbok rugby has similarly had challenges financially, but their teams won the World Cup. People tend to forget that they have similar, probably worse challenges than Cricket South Africa. It doesn't matter, the team's winning. We haven't had any of those. So that's a challenge. I'd like to touch on what we regard as 4 key cricket imperatives. And again, I do believe they're important for the work you're doing, sir. They are not imperatives that we suck out of our thumb. They're imperatives that we sit down and engage with Cricket South Africa when we actually do our MOU negotiations. They are the foundation upon which we negotiate the cricket models in South Africa. And it's actually a lengthy document with a lot more detail, and I've asked Brigitte to actually send it through to you, Mr. July. It's not in my bundle, and probably should have put it in. It's an interesting document to see where the accusations made against SACA that we're not pro-transformation. You need to see that document about how we negotiate the MOU, where every time we say, okay, what's the transformation imperative here? But getting back to the 4 points I've got in front here, we have to have a strong Proteas team, Proteas men's team. Like I said, we've got to compete with India, Australia, and India, who are the big 3, and that enables us to negotiate lucrative deals, broadcast deals, and secure bilateral cricket. If you're winning and you're good, the teams want to play you. A strong team attracts sponsorship, and interest worldwide. And this also speaks to the need to retain our best players in the system, which is an ongoing challenge with so many other sources of income for players around the world.
You mentioned cricket. Is it India, Australia, and
England?
And England.
Yeah.
Yes.
So we have to have the strong Proteas team. And for one, if you want to look at it purely financially, because they generate 80% of our revenue, it's a given. To have a strong Proteas team, you've got to have a strong domestic competition. You have to have a domestic competition that is competitive, effective, because you want players to step up from playing for Gauteng or Western Province, and they can step up into the national team. And that was a very key motivator in our consultations with Cricket South Africa around the new domestic structure, which you've heard a lot about. It was to how do we get more players playing at the highest level, at the best competition, to be able to move from that level into the Springboks. And that introduction of promotion relegation is also critical because it gives context to competition. And that means it's competitive. Every game means something. We are hoping, and we, CSA, SACA, the players, that's going to help players take that step up. More opportunity, better cricket, more competitive cricket. 3, there has to be a strong transformation pipeline. Transformation is an imperative in South African cricket. I've said it up front, I'm saying it again. Players have to be able to develop through the cricket pipeline. They have to have what we call line of sight. When you start playing at that level, you say, gee whiz, if I keep playing and I keep progressing, I can actually play for the Proteas. That's got to be how the pipeline works. And that line of sight means your systems and your structures in place. Your coaches, your provinces need to buy into that and recognize that that pipeline is a cricket imperative that we have to meet. Otherwise, we don't change the demographic of teams. And I'll get onto a bit later on a few points around challenges around the leveling the playing fields. The 4th one, which is relatively new, I say relatively new, I do deal with later, the professionalism of the women's game has really come into being since about 2014, 2015 in South Africa, about 2010, 2011 in Australia and England. We sort of follow them about 4 years. But the growth and the development of the game has been significant over the last 4 or 5 years. And that is similarly has to be an imperative and a strategic initiative. How do we ensure that the women become more self-funding, because they fall under my 80% from the Proteas men, with their own sponsorship, their own market around broadcasting deals. I think it's starting to happen, but that change is not just a cricket change, it's a societal change. People are very quick to say, yes, we support women's cricket, but very few sponsors are willing to put their hand in their pocket and say, we'll give them 10 million rand. So talk is cheap, you've got to actually show. But if you see what's happened in England with the 100, with the women's competition, where they've teamed up with the men in terms of putting on events, there's a lot of development there. So that's another imperative. So no matter what we discuss on cricket, and no matter what has been said over the last couple of months at SJN, I would argue, submit, put it to you that one constantly has to come back to those 4 imperatives, because if they're not in place, the rest is irrelevant. If you haven't got good broadcast deals and a strong Proteas team, it doesn't matter what you want to do with transformation, you're not going to succeed. That's our challenge, cricket's challenge, not SACA's challenge, it's everybody's challenge. And so I put it up front because I think one needs to consistently think about it when one is responding to all the issues that have been put on the table. I'd like to move on, Mr. Chair, and just chat a bit about the South African Cricketers Association. We've listened to the submissions from administrators, some coaches, and we did give a submission on the 6th of May, just setting out some of SACA's history, but I want to give a bit more detail because I think there's some misunderstanding of SACA, its growth, its development, where it is today, how it got to be what it is today. There's this interesting narrative which I touch on of SACA being too powerful that consistently comes up, and I'm really happy to deal with that. But SACA was founded in 2000.
Are you taking questions now, or do you prefer to take questions?
I'd prefer to sort of get through, if that's okay, and sort of have maybe breaks at certain times, and we can. SACA was founded in 2002. Mr. Jonty Rhodes, renowned Springbok South African cricketer at the time, and Mr. Tony Irish, they actually created SACA, born out of the need to protect players' rights, protect players against exploitation. There was no fairness in contracting. Players were being exploited in their commercial rights, and so the Proteas at the time approached Mr. Irish, who was a practicing attorney and very involved in sports law as well, and he then founded SACA with those players. There were no minimum standards. It was quite interesting how players were exploited, and that was a time when cricket was migrating in 2003, 4, 5, 6 from being amateur to professional, and SACA was an important catalyst and assisted in that professionalization of the sport. SACA itself was not financially viable until 2011. It was really run out of the practice of Mr. Tony Irish. He actually covered the overheads through his practice. It was also an employment and labour law practice and sports law and entertainment. And he actually sacrificed personally and financially quite a lot just to cover the overheads and keep it going. It was only until 2011 that it became financially viable to stand on its own. And at that time, it actually only had one employee, Mr. JP van Wyk, who actually still is our head of player services. So I've noted some of the questioning where questions are put forward around, for example, in women's cricket, when it was very amateur, where was SACA? SACA actually didn't deal with any amateur sports people. It only dealt with the professional sports people. And at that time, it was exceptionally small. There were no minimum contracts in place. That was the growth, the start of the game as it professionalized, and SACA got into it. The foundation of SACA's development to where we are today is actually our MOUs, our Memorandum of Understanding, which is our collective agreement between SACA, CSA, and the provinces. It's a large document. The first one was in 2006. We've had one in 2010, 14, and 18. And you'll say, why the 4 years? It goes back to that 4-year budgeting period I spoke about earlier with Cricket South Africa. You have 3 loss years and one profit year. And the objective was to just start ensuring fairness in contracting and eradicate the exploitation of players. And obviously it's grown over the years. On that foundation, we were able to establish a player services department in association with UCT Sports Science Institute of South Africa in Newlands. We launched a Player Plus program. The objective of this was always, how do we start assisting our players holistically? How do we take into account unique personal needs, unique personal goals of players to make them well-rounded individuals, not just a good cricketer on the field, but a person who is well-rounded, is possibly got other qualifications, and we are able to assist them as individuals, as not necessarily just cricketers. And there we started using player development managers throughout South Africa. We have 13 player development managers, one in every region in South Africa. And that player development manager deals specifically with for example, 11 contracted players in Border, looks after them, helps them with their studies, deals with their personal issues, etc. It's about assisting the player. And part of that was developed further, which I will touch on in more detail, is assisting players with bursaries and studying, which was a massive development from our side, to get players to accept that there's a dual career. There's something else after cricket. You cannot just play cricket. There's got to be something after cricket. And also many life skills modules to help players. So where the players are going through relationship problems with a partner, that's a big part of our business, and it's our biggest revenue spend is on that player services department. Our commercial departments, legal departments, and communication departments followed, and we started giving players a number of just benefits to make the player's life easier. For example, our retirement fund started. It's a negotiated benefit. I'll touch on it later, where there's certain allegations about it. We negotiated that, and in addition, the benefit to a player is that the contribution to that fund is over and above his contract. So if a player earns 500,000 Rand a year, 5% of that is effectively over and above. Obviously, there's a tax implication. We negotiate that portion. He gets a contribution, she gets a contribution. We have a paid for, so the player doesn't pay for it. He's got a life policy that covers his life, disability, and funeral benefits for every single player. It's an incredible benefit. I'm actually going to brag a bit here. We sat with Momentum's life division, and we were able to develop a product that caters for a cricketer's disability within his own occupation being the level of cricket he played at the time of his disability. Those of you who understand disability products well, it's part of my past life. Normally your own occupation is if you're a cricketer and a proteer and you're disabled, but you can still play club cricket, you're actually not going to get a disability benefit. What we negotiated and were able to achieve was if a protea's cricketer is disabled in a game, can no longer play because of a career-ending injury, he will get the benefit if he can't play at the proteer level again. That's significant. It's unique in the world. There's no other benefit like it. And credit to Momentum Life and the actuaries who were willing to negotiate with us. Anyway, I digress on being proud of that benefit. We've got subsidised medical aid, paid for gap cover, co-payment, and a past player transition. When a player leaves, there's a period of time for which his medical benefits are continued to be paid. There's some smaller benefits, free Virgin Active membership, for example, and access to Goodfellas service, which is important to some of our players. Such as the success of our programs been that in later years, my players, which is the South African Professional Rugby Players Association, they consulted with us on setting up the same benefits to their players, which they've done. We've also been consulted by SAFPU, which is the Footballers Players Union, purely to try and establish minimum standards for our footballers. There are a lot of our footballers who are exploited. In teams, you'll have varied wage differences between players that are brutally unfair. And SAFPU has been battling to try and create some type of matrix where there's fairness in that, and we've assisted on that. Likewise, the Zimbabwean cricketers have called us up to Harare. Zimbabwean cricketers have really been severely prejudiced over the last number of years in terms of how they're treated, and we've attempted to assist them to create a structure with the assistance of FICA just to protect them, to get some type of minimum income for players who play at international level, but some of them are semi-professional, not really professional. That's a challenge. Mr. Irish, who I mentioned earlier, was recognised for the work he does. He has been the executive chair of FICA for a number of years as well, in terms of all the players' associations. Just on this point, Mr. Paul Adams, in his submission, he said that he didn't really benefit from SACA, and he, to a large extent, is correct. The players of his generation actually stood firm collectively to achieve the benefits that the players benefit from today. That's the nature of the development of a players' association. I'll be the first to say, a player sitting in our structure today, the benefits that they get from SACA across the board are significant. They're brilliant. But sadly, when the development was happening, it's you're building a house all the time. And our challenge is often, where do you go to with this house? How do we improve still? So our players today owe the players back in Paul Adams' era a debt of gratitude for the benefits that they have today. SACA is a sophisticated players association. We're more than just a trade union. That phrase came up in a number of times in submission where people said to you that SACA is just a trade union and they're too powerful. A players association is a specific entity within the world of professional sport and does more than a trade union. The work we do as a players association is no different to the hundreds of players associations around the world. There's My Players Rugby, there's the Professional Cricketers Association in England, New Zealand, Australian Cricketers Association, West Indies, the Professional Footballers Association, which is the English Premier League footballers. I've got a whole list there for you. The most interesting and most powerful one is actually the NFL, the American Football Players Association. It's a phenomenally powerful organization, headed up by a very tough gentleman by the name of DeMaurice Smith, who is an expert on players associations, and they are a powerful organization. But all of us create a collective framework so that players aren't exploited in what they earn with significant benefits. It's the same model all around the world, over 100 players associations, whether it's Japanese basketball or NFL or SACA. We're also a member of FICA, obviously the International Cricketers Association, so we all sit together and we engage with, for example, the ICC, where they exploit players. It's a big part of our work. And we, in turn, are part of what's Uni Global, which is all the players association over 100 players associations in the world sitting under one banner. That's a powerful organization. Incredibly useful during COVID because they were able to, within 2 weeks of hard lockdowns, we were having lectures from professors from Harvard and Oxford on best practice through Uni Global. It is important, Mr. Chair, and this is an important fact relative to a lot of the submissions, that like other players' association, we're the collective representative of the players. We do not play the role of an individual player agent. In South Africa, there are 51 player agents who represent individual cricketers. Yeah. It would have been very, very useful if some of those player agents had come and sat here, because they actually negotiate the individual contracts for players within the collective framework. And they charge a commission of 7.5%, 10% to the player for securing his contract at the province here or there. So there's a big component which hasn't been spoken about here, which is actually the player agent component. There are player agents in rugby, the player agents are well known in football, and they act for the individual. Not only do they secure the playing contract, but they often do a lot of individual work on the individual commercial work, so sponsorship deals, for example. Whether a player is awarded a contract or not, that's a negotiation with the player and his agent in the province. We don't actually get involved in that negotiation. If there's a basis in law for us to get involved, we will. If there's a dispute, we will get involved in that. That mustn't be interpreted as us not getting involved in contract issues that arise. We do. Touch on an example that Mr. Wachipa was involved in. Mr. Manyaka, that's his name, Mr. Manyaka, a player who played for Northern Cape for a while, did very well at Northern Cape. We're talking about the 2017-18 season, am I correct, Brigitte? Yeah, 2017-18. He had a very good season, but he didn't get a chance to play for the Knights, which is the franchise team of that. He had a good season, so he thought he'd have a better chance if he actually went to Free State provincial team. So he engaged Free State. They made him an offer, and he accepted the offer. His contract had come to end, Northern Cape. Free State and Northern Cape suddenly said, hang on a sec, Northern Cape said, you can't take that player. He's part of the franchise. We want him at Northern Cape. So Free State withdrew the offer. Okay. We got involved because clearly this is just good old contract law 101. There was an offer and there was an acceptance. And Mr. Wachipa went and fought the good fight, and Free State then stood down and actually honoured the contract that they'd given him. And he later actually got a franchise contract, which was great. There's an issue that's not about whether a player gets a contract or not. There's a clear contract dispute that we get involved in. And on any given contract period, Mr. Wachipa and Mr. Stephen Cook in our department in play engagement, who's also LLB graduate, are involved on a daily basis on assisting players around that actual contracting element of it. So when people say SACA don't get involved in contracting, we don't get involved in securing the player a contract. We get involved if there's an issue that is a contract law issue that we will fight. Excuse me. It's a dry air in Joburg. I'm not used to, Mr. Chair. I might need another bottle of water. But our relationship with CSA, by the way, is actually, though, no different to that of other trade union employer relationship. We have our fights. We've had massive fights, and I'll touch on them a bit later. Litigation. But we consult on certain issues that we need to consult on, and we negotiate on other issues. We do recognize, though, that for cricket in South Africa to be prosperous and thrive, we've got to actually work together for cricket to thrive. And that's an important position we take when we engage with CSA. The last few years have been difficult, as you'll see. 2019 and 2021, that period, open hostility. Litigation, we were going to be in the Gauteng High Court here. But we have seen a great improvement in that. And that's evidenced by the fact that in the last season, through extensive consultation with CSA, we were able to agree the bubbles for players to play domestic cricket in. We had our doctor involved, which was actually Dr. Mohammed Musaji, who you met, and CSA's doctors, and we got best practice. And it worked like a charm. And that is a great example of CSA and SACA working together, protecting the players who were a bit upset about bubble life. We had to guard them and guide them in that regard, and CSA working together. We are a dynamic organisation. We've constantly got to change to keep up with changing times. We've always supported the concept of player activism. It's got an interesting history, player activism, and when Lungi Ngidi came out in July last year with a statement of supporting the BLM movement, we came out immediately when there was some criticism of him, if you recall, from some past players. We came out immediately as SACA, and I've got the annexure there on page 137, where we supported him. He's right to do that. And we made it quite clear that as SACA and as CEO of SACA, we absolutely committed to the transformation and diversity. And that was back in, it was a 10th of July 2020 release that we put out 2 days before Lungi had made that statement. I also had a number of, I had conversations with Lungi at the time, who I think felt quite upset that he suddenly was in the middle of Twitter war about it, but really backed him. And I think if you look at the history of player activism can lead to collective activism can lead to change. That's the nature of that sequence of events. Has happened in sport all over the world. Maybe I can pause there and take some questions before I move on to the next section, which is my response to some specific narratives. So just give me a moment to blow my nose.
No, I have no questions thus far.
Yeah, we'll ask questions later on.
Okay, thank you. Moving on. So I mentioned up front that there were these, throughout the submissions that you would have heard, they were what I'm not saying they were generally accepted, is that we saw certain narratives come through. And what I wanted to do in the affidavit was pull what I regarded as really important narratives that I wanted to answer to. And that's really what the next section is. And the first one is that SACA is too powerful. I heard it often, and it was somewhat irritating, but it was a general statement made. And the reality is SACA is the players. SACA strategic direction is determined by a SACA executive committee, which is voted for by the players. And you've met Kaya Zondo. He happens to be our president at the moment. And we sit down and we have discussions about where we're going as SACA. So when people say to me, SACA's too powerful, SACA isn't Andrew Britsky sitting here. Not at all. Andrew Britsky is a servant of the players. I sit before you today as exactly that, a servant of the players. And so when people say SACA is too powerful, they're saying players are too powerful. Does SACA do good work? Are we good at what we do? Again, I'm going to boast and say we're damn good at what we do. We do it well. We work hard. So if people want to think that being too powerful means you do a good job, well, then I can't change their minds. But really, it's the players. CSA is the custodian of cricket in the country, and SACA respects that role. It really does, and we consistently ensure that we don't encroach on their domain and their authority. It's a constant issue that we have to deal with. In the governance crisis that you're aware of last year, when there was an interim board, a number of stakeholders approached me and said, SACA must have a representative on CSA's board of directors. And I said, not at all. We have no place being on CSA's board of directors. A director at CSA has got a fiduciary duty to CSA and does not have any duty towards SACA. And that is something that we guard against absolutely clinically. We don't go there. CSA, we respect their management prerogative. CSA had the right to change the domestic structure. It's their prerogative. Our collective agreement says they must consult us on that. They don't have to negotiate with us. They must consult with us. And as you would know, Mr. Chair, there's a significant difference between the two. And that's why our collective agreements are worded like that, because we respect CSA's role in that regard. I do believe that the narrative of SACA being too powerful is because we do bump heads on an ongoing basis on issues and terms and conditions with the provinces. Mr. Wachipa is currently dealing with an issue on the player contract at two of the provinces where the provinces are in breach of the player contract. We don't stand back for that. We go and we represent the players and we say, you're in breach. Does that irritate the province? I'm sure it does. Does the province turn around and say, gee whiz, these guys are troublemakers? They probably do. I do believe that that is the basis of where a lot of people's, this narrative of SACA is too powerful comes from. I will deal with more of these issues as they unfold in the individual responses, because they were born in some of the individual responses where I need to deal with them.
Why do I want that issue of SACA being too powerful and give you the context so that you address it? Because I agree with you. If it's not powerful, then it must stop to exist. But there's a context. It would seem that players, in particular black players, think that they are powerful senior players who are represented by SACA, who have too much influence in SACA, and as a result, SACA is so powerful to influence what happens at CSA, and those views are the views of the senior white players. And that is where the issue of, that is why it is said in a negative. Because I don't see why players would be negative about SACA being powerful. So they are raising it in that context, that it is powerful and powerful for a certain section of its members.
And more specifically, that they are senior players,
yes,
who have an inordinate influence on SACA, and would be perceived in some instances, and that's how it comes across, as people who dictate, how SACA should conduct itself.
Yeah, I find it difficult to understand that when effectively as I mentioned, the SACA Executive Committee, which is an elected committee, and Kaya Zondo is our current chair. Temba Bavuma is on that committee. Faan Beardin is on that committee. Grant Thompson is on that committee, and Mignon Dupree, as one of the protest women, is on that committee. And prior to that, we had Umpile Ramela, you've heard, on that committee. And it's difficult to me understand where one would think white players have got undue influence in us, because that committee determines a strategic direction. The MOU does. And I remember commenting to Mr. Wachip at the time, if some players would come and give us an example and say, this is where I feel, it would be probably much easier for me to answer. But I really cannot accept an argument where we are too powerful for white players, when actually our membership at the moment reflects the contract membership, which is, and I might be off a few, 100 white players, 70 odd Black African players, and 55, I think it is black players, 77 Black African players. So our membership is predominantly non-white. At a Protea level, if you're looking at the senior players are actually Black African players in the Protea setup at the moment. You're looking at Kagiso Rabada, Temba Bavuma, Lungi, etc. So I hear you, sir, but I'm finding it difficult to understand where that undue influence might be relative to how I, as CEO, have managed SACA relative to my executive committee. My executive committee, in the periods of COVID into this year, we were meeting monthly, which was quite onerous on them, specifically to try and get the right direction in this very difficult period. So I hear you, but I'm struggling to respond to that in that context.
What I'm saying is, you are right, it was raised as being powerful, but it was not a positive thing.
But
when it was being said.
It was seen as, and that's why I think the players I agree with you, the players must be powerful, otherwise what on earth are we doing here? I think one of SAFPU's challenges is to become more powerful, to get minimum standards in. It's that ability to enforce a position to protect players.
Mr. Britsky, on that point of SACA's power, there's also been a view I think that might have been mentioned in the SJN hearings regarding SACA's. I think the view was that CSA has relinquished too much power to SACA, and that's like also where the power dynamics came up. So I don't know what your thoughts are on that, but they found that but the view was that SACA has a lot more influence on the players than CSA does.
Let me answer that carefully, because every trade union pushes boundaries. That's what we do. I acted as an attorney for trade unions, and you push boundaries. So I think there's part of that which is the very nature of what a trade union is. Okay, but having said that, I still, as a professional, recognize where that prerogative of CSA is. So a good example is the restructure that ended up in litigation, where CSA had the prerogative to restructure, but they didn't consult us. We recognize that it's their prerogative. Where people say CSA has relinquished power, I think there's a lot of collaborative work. So if CSA want to establish a new MSL T20 league, they will bring us in for a brainstorming and say, what do you guys think? And if people think that's too much power, they also need to recognize that we say, listen, guys, it's your decision. We've got good ideas. The reality of SACA, Advocate Ngele, is we have a lot of cricket intellectual capital. We do. CSA have lost an incredible amount of cricket intellectual capital in the last 5 years, to their detriment. Okay. Whether people see SACA as being consistent in terms of what we do and what we know and the statements we come out of and the positions we take, and seeing that as being undue influence, maybe that's a position. I do believe it's a perception. I will not, however, say that we don't try and push the boundary as a trade union, because that's what trade unions do. But at the same time, it's incumbent upon CSA to say, back off, this isn't your issue, which they do now and again. I currently have an email in my inbox where someone's asking me a question and I'm saying to them, it's not my business. This is something you need to sort out. So I understand that. But again, our engagement with CSA, and this is a very important point, is absolutely no different to the other player associations around the world, first of all. And second of all, and I'll get to it just now, I think one has to understand how professional sport works relative to how player associations work, because they are powerful in what they're able to do. So I hear that. I think Mr. Romela said that as well. He felt we had too much influence. But when you're a trade union, you sit down and the employer is doing X, Y, and Z, and you sit down in a meeting. One of the things you say is, guys, how do we influence this? We don't like where this is going. It's what you do. You strategize around it. It's trade unions.
Again, I need to emphasize this point, that this power, it's seen by black people as you are so powerful to the detriment of black players. And I think that is where the issue is. Not to say they don't want a powerful trade union. If it was powerful for everybody, and I think those players who came here and make those allegations would not have made them. They would say, we are protected by SACA. It's so powerful. We know that nothing can happen to us. But it's viewed by those who are here, and in particular, those black players, as being a power which is to their detriment.
I hear you. Let me hope that by the time I've finished my submission, you will have changed your mind.
Yes.
That's what I'd like to respond to that.
I'm not. Remember, I'm stating
I know
what has been said here.
Yeah. I disagree with that. But
Yes.
if a player has a perception, I'm not doubting a player's perception.
Yeah.
All I can do is take you through this and hopefully say, well, actually, that perception isn't grounded on sound facts. And that's what I hopefully will achieve.
Yeah.
But I'll keep that in mind. Okay. Moving on, which touches on that issue probably as well, is under Clause 34, SACA is anti-transformational or neutral on transformation. That is a frustrating, and I do believe, inaccurate narrative that came through from a number of players. And it was put to players by some of your questions to them as well, because it isn't true. We are fully supportive of the transformation initiatives, and we've consistently advocated that we've got to get to a point where cricket reflects the demographic of South African society. We've sounded a bit like a stuck record sometimes when we've said that. It is an imperative we support. It appears as if that position comes from the fact that we don't play a direct role in the setting of targets and in the actual selection and contracting of players. It clearly comes from that element. And that's something I'd like to unpack a bit, because as we stated initially, selection, be it for a team or contract, must be the prerogative of Cricket South Africa, or in the context of a province, the province. That prerogative has to sit there in terms of selection. The issue of independence of selection is fundamentally critical to the success of our sport. It really is. I'm actually going to be at pains to emphasize this point. It's critical to the integrity of the game for a couple of reasons. If there's interference in selection, it breaks down confidence in selection. The development of teams and squads is undermined by interference in selection, and conflicts of interest arise. There are always conflicts of interest that come around. Mr. Linda Zondi mentioned how challenging selection was. He also mentioned, interesting enough, how much pressure is put on him by various stakeholders who have an opinion on the selection. Mr. Hussein Manak also actually said in his submission how challenging selection was. We, and when I say we, I'm using a very royal plural here, we, SACA, individual players, Cricket South Africa, etc., sponsors, we're totally dependent on the independence of a selection panel, that they do it fairly and objectively, and that holds the key to success. Take, for example, Kaya Zondo situation that it's been unpacked at length at these hearings. If you get to the core of that, if you cut away all the narratives around that, what was at the core of that? It was an admission by the selectors that they didn't actually maintain their independence. That's actually at the core of that. And to their credit, they admitted that in their submissions. We have to protect the independence of the selection panels. And it was mentioned by a number of people, including Mr. Ashwell Prince, who didn't have any kind words to say about SACA, but he made the point that independence of selection is important, and as did Mr. Ramele. There's no other players' association who has input in selection process. It's not something we get involved in. We create the collective framework from which contracting can take place. Where we are different from the normal industrial relationship is that this isn't about employment as we understand it outside of professional sport. You have a capped budget and a finite number of players. That's all it is. And that is a constant conveyor belt as players come in and players move out, etc., etc. And that is something that is different to a normal employment scenario. And one has to also remember that is significantly different. And selection by its very nature is differentiating. You're differentiating on players that are sitting in front of you of who I'm going to select. It's the very nature of what it is. And there's a player who's going to get selected, and there's a player who's not going to get selected. Just for interest's sake, there's a crisis in Kenyan cricket at the moment, and I mentioned it there in paragraph 34.6. In March this year, the Kenyan government actually created a cricket normalization committee to actually investigate cricket. And the first point raised by players and coaches was that the Kenyan player selection committee must be completely independent, because they have battled with people getting involved in selection. So it's a starting point for the players. They want faith in the system. And I do believe that this narrative that SACA is not pro-transformation is related that we don't get involved in the selection, and we don't. And again, it's something we raise with our exco and players to say, this is our position. Are we consistently supporting this position? I do think it's important to note that we are a member of CSA's Cricket Committee and CSA's Chief Executives Committee. And And the issue of transformation is on those agendas at every meeting. And to say that we don't get involved in the debate is wrong. We do get involved in the debate. That's where we get involved in the debate. For example, you would have picked up, I have a reference to the commoditization of the players, which I will touch on again. It's in those committee meetings where that discussion is had around how is transformation being unpacked. Mr. Max Jordan has a standing agenda item at every meeting on transformation. Ironically, I think the argument that SACA is too powerful would be very real if we started getting involved in the selection of players, because there you are directly involving yourself in what teams look like and teams are. And I'm the first to say, I go back to my brutality of professional cricket. Players, every contract year, they are unhappy players. They're saying, why on earth am I not getting a contract now? Why on earth have I not been selected? The selection for the Proteas T20 World Cup team now, they're players who are going to be disappointed that they weren't in that squad. That selection panel must stand or fall by effectively those individuals.
Now, Mr. Breske, you started by saying you would want cricket to reflect the demographic of this country. If SACA adopts that attitude, well, by demographic, I think you would start from the grassroots up to even Pro T. It's not an island. It's not excluded in that. How do you then make sure, as SACA, that indeed the demographics change if you don't get, I'm very careful about you being involved in the selection, but if you have no influence in the selection of black players,
when you say influence in the selection of black players,
yes.
How?
You suggest that the selection committee must be independent. They must do whatever they want to do, right? I'm saying as SACA, you subscribe to transformation and that the cricket must reflect of the demographics. How do you make sure if you are going to allow the selectors to continue giving or selecting white players? Why would SACA say we don't want to be involved?
I think one has to take one step back and go back to my point about we have to trust selection. We have to trust that the CSA's transformation targets that they set are met. We have to hold CSA to account to that in terms of on those committees. So, and I'll get to it just now, is to why are we not able to achieve targets? The reality is that if CSA is not able to achieve transformation targets, because those transformation targets are there to transform the team, which is why those transformation targets have changed over the years. We have to trust that the selectors actually achieve those targets because they need to stand or fall by them.
And if they don't?
If they don't...
In spite of the trust?
In spite of the trust, if they don't, then our position with CSA is they need to, for example, remove a selection panel. If a selection panel doesn't achieve that. The transformation committee, and this is an area that I think does require, and again, we don't sit in the transformation committee. I'm offering an opinion as to what I would hope would assist the Ombudsman. I believe the transformation committee should move away from looking at what are statistical analyses of player profiles, which they have strong information on that, and to, why are we not able to achieve certain targets in certain areas? And that's actually where I believe that remedy lies within cricket, which is where I think our role stays on the cricket committee in terms of where are we with transformation. I understand the point you're making. I understand you would say, well, should SACA be more actively involved in canvassing on the selection of black African players in the team? And I would say it's not part of the SACA mandate when we represent all the players who are contracted. Remembering that a player who gets selected is also another member who doesn't get selected. We have, that's an element of a conflict of interest that we have.
I was going to go there. It goes with what you perceive to be a conflict.
Yeah.
Because you don't want, for instance, to say Sandile must be selected and then you leave out John.
Yeah.
Because now the problem there, you see that there is a conflict. But there shouldn't be. It shouldn't be a conflict. Because if everybody buys to the agenda of transformation, remember there's certain discrimination which is justified. If you want to, the agenda is to have the demographics right. So whatever form of discrimination which seeks to address that will not be unfair.
I suppose one's almost getting into an interesting academic debate here, which goes, I think the case is Dudley versus City of Cape Town. It's a Labour Appeal Court case. The doctor, if you recall. Whereas what is the purpose of an affirmative action target? And the question was, is it a sword or is it a shield? And the court turned around and said, well, it's a shield, to say, well, we haven't employed you because you're white because of affirmative action, rather than someone being able to claim a position.
But we have to be careful about that judgment, because that judgment deals with the issue of where you don't have a plan. You just wake up.
It does.
Yes.
But
you just wake up and say, I'm not going to employ so-and-so, and it is arbitrarily.
Well,
but there is a plan.
Yeah, the remedy in that case, which the court said, was, well, effectively what you must do is you should actually lodge a complaint with the Department of Labour, because effectively, if you believe the plan isn't being implemented properly, that's your remedy. That's why I'm saying, where we're talking about a target in cricket, that's effectively where the Transformation Committee, I believe, needs to have a different type of role. So currently, in the last season, I think there was one team that did not meet the transformation target on a specific game. I stand corrected, but I think it was one. That team effectively has to submit a report to the Transformation Committee for there to be approval of it. I believe that process is too simplistic, because it's easy to get yourself into a position where you can't meet the transformation target. So I think the debate we're having is a debate that can go further into what structures are there. And I'm happy to say, and what role should SACA play relative to those structures, where we currently play that in a CEC meeting and a effectively a cricket committee meeting. What is interesting, and I think it is an important point, is because you asked the question, and I want to deal with as many questions as I can. We have not had a member in my time at SACA come to me and say, we don't want these transformation targets, irrespective of race. We haven't had that. What we have had is a player coming to us and saying, I wish there'd just be clarity on the transformation targets, black and white, which is a very different statement. It's confusion that creates animosity in a system. Certainty puts people at peace. So you have asked that question of us later, and there's my answer. We actually haven't had players who've come and said that to us, because players do recognize that imperative. And we put it out there for players. In our sessions with players, this is an imperative, guys. It's fundamental to where we are in South Africa at the moment. It's an imperative.
Mr. Britsky, does SACA have its own policy on transformation? And if you don't have a policy on transformation, where can we find in your documentation SACA's clear stance on transformation?
We don't have a specific policy on transformation. SACA has transformed quite significantly in the last 2-3 years, actually, in terms of its own demographic. But within our MOU, we specifically state our support for the transformation initiatives of CSA. That's an imperative for us. We've put it there. We've also put it as public statements within our AGMs, where we've actually, in the last year, specifically adopted certain measures we want to take because we need to play a role in achieving the transformation agenda of CSA. And I think that's what the BLM movement highlighted for us, which I will touch on some more as well.
Yeah. I think also you may have to go beyond the debates. I know that you participate in the debates because the transformation is an issue, is a standing item on the agenda. I think it has to go beyond the debate, because that debate must translate into an action. So if SACA, for whether you've got policy or no policy, it doesn't matter for me. But what matters is you support transformation, and having supported transformation, you make sure that indeed transformation does happen.
Yeah, and Mr. July, I'll get to another point just now where I deal with what I call a couple of more imperatives, which I think are critical in understanding where I think the challenges in transformation are. I think the concept of transformation in specifically cricket is misunderstood. If you say transformation to a group of people, someone will talk about the targets. The next person will talk about facilities. And there's no, I believe there's no clear, cohesive understanding of that term transformation. But I will touch on that because I think that's important to what we're discussing as well.
I think there's more education which is required there.
Yeah, but there's action on that. There's clear action on that I think can be taken.
Okay.
Because if you want to change, then you have to change across a number of elements. Education is part of them. But I will deal with this now.
So, Mr. Prescott, just before we move on the point of transformation, in your affidavit, you do say that the Proteas must be representative of the South African demographic, as Mr. July also repeated. I want to know, it's a question I've asked also to the cricket unions, is SACA's management representative of South Africa's demographic?
I do touch on it. So I'll touch on it just now. Okay. Sorry, can I get to it?
No problem.
Otherwise, I'll make a mistake.
Yes.
Yeah. I do. Oh, sorry, I'm just lost my spot. Yeah, I'll get to. I'm on 3410. I'll deal with a few more issues under Advocate Orenser, and then just summing up, where our transformation can be summarised relative to 4 different levels. We are fully supportive of CSA's transformation initiatives and targets, and recognise CSA's prerogative. I've said that. The negotiation of a contractual framework is so that players aren't exploited. That is critical to the work we do. There must be no exploitation. And just now when I show you the whole matrix, you'll see how that works. Our implementation of our Player Plus program is actually to make sure that every player, every race, actually has more to life in cricket. And the work we do amongst our Black African players is significant here, and I'll touch on that as well. And then I'll touch on it a bit later again, our specific initiatives on transformation and diversity, which I will deal with. 35 is related to a lot of what we're talking about as a narrative. SACA is not able or suited to represent and assist Black African players. I won't beat around the bush. That's a devastating narrative to hear when a player says that. I don't want to hear that. I'm CEO of SACA. I'm committed to the player cause, and to hear that is not nice. Initially raised by Mr. Etienne Balati, Mr. Ayamoyola, and then it was put to subsequently to individuals throughout the sessions. Why I say that's devastating? Well, it's demoralizing to my 10 employees who sit at my SACA head office and my 13 player development managers who just work tirelessly to assist and represent players all the time. On any given day at SACA, one of the employees is assisting a player through his or her personal crisis, a life decision, a contract dispute, a grievance. So we're there for them in their darkest hour. And similarly, we're there for them to get a new career going, whether it's studying, personal development. And that's done without fear or favour, every single player. So when I hear this narrative, it is upsetting. And what I've done in 35.4, and I want to go through these carefully, is this is just, when I drafted this, I went and said, what have we done in the last 3 months, specifically for Black African players? And just so I could take a snapshot as to any period in the history of SACA as it might be. So in this period, we're currently still assisting 2 players who've got substance abuse problems, obviously having a serious impact on their careers and their lives. We're paying for the rehabilitation and providing counselling support to those players. A player who has a career-threatening injury which could result in him losing his contract, he's been supported through our medical benefits, and likewise we're providing that player with psychological support because it's a major issue for a player having to go through that. A young player from a township was not able to complete his grade 12, and he ended up fortunately getting himself a professional cricket contract. When a new player comes in, our player development manager sits down with every player and sees where they are at in life, and was identified that this player does not have a matric. So we are now ensuring that he completes his matric, putting him through a college. We're paying for his tuition and all the support. So he has ongoing tuition support. A young player who has a study bursary with SACA, he started studying and then he said, I can't keep up because I don't have a laptop, I don't have any wireless We provide all those resources so that player can actually study properly. Given the high number of players who lost their contracts at the end of last season, we had 75 players lose contracts with the restructure, which suddenly means a player just doesn't have an income after April of that year. We created the SACA Hardship Fund to pay for the food and rental of players through that period. And that fund was initially created to assist with COVID, with the hard lockdown as well. And that breakdown for the end of contract is 73% black, 73% black African, 14% black, and 13% white, where those players could apply and were then given money for food and rental till they got on their feet again with employment. And again, there's nothing more rewarding than getting a WhatsApp message from a player saying, "Thank you, SACA, you've saved me. You've kept me going in the darkest period of my life." In the aftermath of the KZN looting and violence, which we're all aware of in July, we contacted every single player in that region to see how they were doing and to try and see what their situation was. And this was very much an initiative driven by Kaya Zonda, our president, given that he came from the area and was experiencing the hardship. And we came across 4 of our players and 3 academy players. Academy players are not members of SACA, they're amateur players. But we came across those 7 players who didn't have access to food or other basic necessities. And with that, we actually went and we managed to have those items purchased for them and got them delivered, despite the massive logistical challenges we had. That was, when there's a crisis, we actually get on the phones and we phone every single member of ours. Players who are currently in dispute on contract issues, Mr. Wachipa and Mr. Stephen Cook are currently assisting them, be they where accommodation issues that they thought they had to deal with, which they haven't. There are all sorts of disputes like that, like Mr. Manyaka, who I mentioned earlier. A young player recently lost his contract. His mother required emergency medical attention. He had nowhere to turn to, and he turned to us. And we made the funds available to him to assist his mother in that moment of crisis. And a player who found himself in serious financial predicament with litigation pending against him, he came to us and we provided him with financial counselling and have referred him to attorneys to assist him, and we've assisted with the legal fees for that attorney in what is really a difficult situation for that player. And finally, a player who passed away suddenly, whose father passed away suddenly, he suddenly had to pay for the funeral costs, and he was not able to do that, came to us for assistance, and we provided funding. I mentioned those as 10 issues in the last 3 months that we're dealing with black African players. We're helping them, we're assisting them, we're trying to make their lives better for them. It's about promoting and protecting the best interests of all our members, and these members happened to be black African members. So when people say we can't assist black African players, it hurts, because I refute that. On an ongoing basis, we are there for the players. It's what we do on a day-to-day basis. It takes hard work and dedication from our team to achieve that, as you can imagine. And I'm proud that we're able to assist players like that, because it's what we are. It's players for the players. The decisions to fund, for example, the Hardship Fund, is the SACA Executive Committee saying, let's put aside money for players. It's players for players. I want to move away from that narrative that people think SACA is the CEO or people who sit in the office. It's actually the players who make those calls. It was Kaya Zonda's call to actually say, let's phone every member of ours and see how they're doing in KZN. And it was logistically a nightmare to sort that out.
Mr. Britsky, thank you so much for that. I have no doubt that SACA is doing great work and is supportive of all its players that are part of the union. And I've noted all the different types of assistance you've provided to players. But I don't think the section addresses what was raised in the hearings. So, for example, in paragraph 35.1, you refer to Mr. Ayamyoli. Mr. Ayamyoli, in his affidavit, had stated that there had been an assault. He had been assaulted by another player. And in that particular instance, and it was a white player who had assaulted him, and that in that instance, SACA didn't intervene or didn't come to his assistance. And these forms of assistance that you've provided to black players doesn't address that complaint or query that, complaint or concern that he came with to the SJN?
Yeah, I will get to IRA. So I've got a section on IRA because I accept that's where his complaint is coming from. Yeah. Moving on to 36, a section that SACA is only focused on the commercial rights of players.
Maybe you should go back to that after lunch.
Okay.
That's you have been very fast. Time has been flying. If let's make it 2 o'clock, so it's just about half an hour's
Okay. Thank
lunch.
you.
Okay. Where is the meeting? Is it on these premises?
Yeah,
or?
I'll just do it online. So.
Okay, all right.
Mr. July tells me he's hoping I'm finished by then.
Yes, and so do I.
I thought it was interesting, sir.
No, but I'm here. I'm condemned to be here forever.
I will attempt to
Okay.
proceed swiftly.
Okay.
Moving on, my paragraph 36. The narrative SACA is only focused on the commercial rights of players. This just isn't true, and it's a misunderstanding of the work we do. I have to say it's disingenuous of Mr. Ramela to present that argument, because he was a member of the SACA Executive Committee for 6 years. He's acutely aware of the work we do. He's benefited from the work that we do as well. I just need to put this into context for you. We negotiate what's called a player payment pool with Cricket South Africa. And as you'll see in the footnote there, it's the total cost of the Proteas men in domestic cricket over 4 years, obviously broken up into each year. It's the cost of playing cricket in South Africa for the players. And that, for example, in this current season is 190 million rand, 968,000 and some change. Of that 190 million rand, 27 million rand is the players' commercial program. That's 14% of that entire PPP. It's minimal relative to the actual cost of the player body and the work that we have to do relative to that player body. Of the 10 employees I have at SACA, 1 is involved in managing the commercial program, while 7 are directly involved in managing the players and the player services. So that's 14% of revenue, 10% of my staff. That's clearly not only focused on the commercial rights of players. It doesn't work like that. Our core business is protecting and promoting the best interests of the players across the board. And that's why our player services department is our biggest budget item. Importantly there, our Player Plus program, and I'm going through some detail here because it's important to understand where that work is focused relative to the statement we only care about the commercial program. Every player undertakes a player development plan when he starts playing cricket with one of our PDMs. This is a tool that determines what lies ahead for the player. It's a record of his completed supported actions, his studies, etc. And just by way of example, in the financial year that's passed, so that's February 2020 to February 21, March 2020 to February 21, each player, 304, did a personal development plan with his PDM, focusing on dual career personal development, that's their life skills and their wellness. 257 of those players, that's 85%, are on active plans. We don't force a player to do that, but we have an 85% strike rate where players are actually actively engaged on their plan. We awarded 127 bursaries with a good pass rate of 99.2%, and that covers BCom, sports science, engineering, law. You'll be very pleased to know that Mr. Eddie Lee, who you saw a few months ago, has just graduated with his LLB. And I was very pleased, Mr. Lee, I don't know if I actually have the message here now. He sent me a message.
He was grateful.
He was very grateful to SACA for funding it.
Yeah, when
He was very grateful for SACA, and I've got a good relationship with Mr. Lee, and he even thanked me personally in the message. He's one of those 127, and makes us very proud that a player can achieve that. And that includes a player like Mr. Lee, who's actually was past his career. His contract had ended. We had a total of 142 life skills modules that we did with players, and that's everything from financial wellness, mental wellness. They listed all there, even up to media training. And we referred 31 players to psychologists effectively to support them, which was an interesting number because it increased as COVID took hold, where players needed support under the COVID challenges. Important to understand in terms of our focus is this isn't just an arbitrary sit down, what do we do for our players? We've actually teamed up with University of Cape Town, which I mentioned earlier, and to make sure that everything we do is on a scientific basis with Dr. Sharif Hendricks, who's at UCT, consults us to make sure our program is world-class and on tune. We've had research topics including anxiety and depression in athletes, psychosocial analysis in transition of athletes, and our current one is a very relevant one because it's been raised here as well, is meaningfully employed, underemployed or unemployed. What are the factors that influence employment after a professional cricket career? That's important for us because speaks to how we assist players in their career. I note then 36.6, we're extremely proud because anxiety and depression in athletes has now, as of September, been formally published in a medical journal. And because I know you're very interested in that, I've put the reference at the bottom. You can go and read it about the depression in athletes. This program of ours, which is our focus, not the commercial program, this program of ours is internationally renowned, and my staff actually travel internationally to present on what we've achieved. It takes manpower, time and finance to get this done. It doesn't just happen overnight. So to have a narrative that SACA is merely there to look after the player commercial interests is not true. It's 14% of the PPP revenue. It's 10% of my staff. I think what I've just gone through clearly shows where we are looking to make a difference in players' lives. Another important narrative under 37 is SACA discriminates in the payment of bonuses, which is the complaint that you received from the Black African cricketers. We're not actually aware of the Black African cricketers as an entity. It was an anonymous complaint you got, but it would be nice to have specific allegations to answer to, because I think that would be fair on us. But be that as it may, I'm more than happy to engage and respond as you see in my affidavit. The point one concerns wage discrimination, and that's really something CSA I think will answer to, although I will touch on it just now with Mr. Pangiso's submission. But point two relates to this wage discrimination over SACA bonuses. So a couple of points. We do not pay wages or bonuses, SACA. The payments players refer to are payments that come from the players' trusts, the South African National Cricket Team Trust, the South African Professional Cricketers Trust, and what we call the SACA Trust. I wish to state that it's objectively impossible to unfairly discriminate against a player in these commercial payments, because the payments are based on objective formula. And I've got in the bundle on page 139, 140 and 141, 3 graphic illustrations of how the formulas work. They've been developed in consultation with players over the years. And so, for example, if you look at page 139, this is the South African National Cricket Team Trust that relates to the Proteas. You will see that there's a formula that sets out how this money is distributed. 80% goes to the players, 20% comes to SACA management. It's a management fee. It's what funds all our other activities. At the top there, you'll see activations. If a player does an activation for one of Cricket South Africa's sponsors, he will get paid. And the balance, the 90%, you will see that goes to the players. There are 2 shares. If you've got a contract, you get an equal share. So if there are 17 contracted Protea players, it's divided by 17. The second share is the match points, which has been canvassed often in the hearings. The match points are based on 3, 1 and a half for a T20, 3 for a test, 1 for ODI and a half in a T20. If you're part of a squad, you get half a point as well. And that's the basis upon which, for example, in that trust, it's paid. You can look at the other as well, they're there, which just illustrate in the other trusts how it's done. We have...
If you earn less, it could be, if you get less than other people, it's not based on, it could be because you did not participate.
Exactly. I say there in 37.3.3, we have the most comprehensive list of every single payer payment that SACA, that the trusts have ever made from 2005 to 2021. We did chat to you on the 6th of July, Mr. July, on actually you guys having access to that. We did get legal opinion on some confidentiality issues, and as we said, I'm happy for us to fly up here and sit with you in the office, and you can go through every single payment you want to go through. I would welcome it. Please.
Yes, almost we've made an agreement on an undertaking that explanation with the information contained there will be brought to our attention, and we'll have a meeting where that is being presented because it's confidential.
Okay.
Yeah.
Okay.
Thank you. I do believe, Mr. July, when you go through that, you will see that the notion of there being unfair discrimination will be put aside. I also think it's very important because I think there's misunderstanding in some of the narratives of commercial rights payments have a specific purpose, and they come from the commercial agreement that we've entered into, that the trusts have entered into with Cricket South Africa and the provinces. So when Cricket South Africa get a sponsor, effectively the sponsor wants mileage, be it Momentum or Betway or whatever, and to get the mileage, they want images of the player. They want the attributes of the player. And effectively, when the player joins SACA, as a union, he can join one of the trusts, and he grants his right in the collective to the trust. And that's effectively where the agreement is, between the trusts and CSA and the provinces, and we as SACA administer that for the player. So when a player runs out on the field in a Momentum one-day cup match with a Momentum on his shirt, then effectively he's almost participating in an advertisement for Momentum in that sense. So he gets recognized for that financially.
So the player sees his rights to SACA, and then SACA sells the rights.
The trust.
The trust sells the rights to CSA.
Yeah. And effectively, from that money, the player gets paid. And that's where it happens.
Paid by whom? By CSA?
By the trust.
By the trust.
Yeah. So, and again, when you actually see the spreadsheets, it becomes very clear how it works. There's an activation, there's the match fee part, there's your contract part. You can actually see how the players are paid in that. So the two key objective criteria that work for our commercial rights payments are, one, if you're contracted or not, because that's 50% of the payment. So even if you don't play a match in the entire season, you're still going to get 50% of the payment. Yeah. The other 50% is then based on your match fees. And you'll remember, I think Mr. Lee mentioned match fees at some stage. So if you play all the matches in a season, you're going to get a higher amount there. If you don't play any matches, you're going to get a low amount. That's how it works. And it's not a bonus, it's linked to your image. It's linked to your attributes as a player that Cricket South Africa and their sponsors and SuperSport are actually utilizing. Because as you'll see just now, I'll get to it, where I start talking about the different components of that make up a player's earning ability in professional sport. This is unique, it's in professional sport. You're not going to find it anywhere else.
Is this explained to the players though?
It is explained in detail.
Okay.
It's explained every year when we go to the players. One of the challenges, Mr. July, is some players listen to you and they don't necessarily, then they come back and say, oh my word, where did that come from? When we make payments, Mr. Emil Dre, who's our head of commercial, his phone doesn't stop because players phone and say, how did I get this? Well, how does this work? Why have I got 55,000 Rand? Thanks, break it down for me. Great. And of course, every year we give a player a total breakdown of where their money comes from because there are tax implications. We pay tax, trusts pay tax on their behalf. So they have to get all the information that they need. I do believe, Mr. July, I made a note here that when you've gone through the schedules, you'll see how incredible the system is for players, one, and two, how it can't, effectively the formula can't discriminate in that sense. It's dependent on the selection of the player. Just in the case of Proteas, they're awarded for being part of a squad as well. That's also an important part to understand. And that's also relevant in the submission of Mr. Lee. On 37.3.8, it's important to note that the commercial rights model is there are three main areas. Player appearances. So if a player goes and does an appearance for a sponsor, so you would have seen a player at a KFC day, for example. He's actually getting paid for that because he's promoting KFC and the trust will pay him. There's player content performances. So if a player tweets something, he'll get paid for that. And the player attributes is when a player runs on the field. So he's actually advertising for Betway or for Momentum, whoever the sponsor might be. And that's how the model actually operates. So the matches played is linked to the player attributes.
And the agents of these players are supposed to know this, don't they?
They do know it because very often the agents, we work with them on the finances of it. So yes, they should. The agents, you must also remember, are involved in getting individual sponsorship rights.
Yes, the individual.
Yeah.
But as an agent,
they should
know.
Of 51 agents, there are good agents and there are bad agents, as there would be in any sport. So that's a reality one has to deal with. But yes, they should. And we actually explain it to the agents as well. The one question that came through from yourself, Mr. July, earlier on was this concept of, are players getting their right commercial value? That's a very interesting question, but I do think it's important to understand that we're talking about the collective as compared to the individual.
Yes.
And we will constantly argue as SACA to increase that commercial value. But there's some science behind it. We've contracted an organization, a company called Nielsen Sport, and that's what they do. They determine your collective value as a group. And they came out that we probably slightly undervalued with the Proteas, but we overvalued with the domestic competitions. So that's something we've got to manage. We're also currently working with a company called Moonsport on something quite interesting, which is what is the value of a player's social media. So we're currently tracking through Moonsport, if a player tweets, "Thank you, Momentum Health, for excellent service," how far does it go, who sees it, and what's the value of that? Because that helps us to be able to go back to CSA and say, well, you know what, the tweets of the player, this player, it's worth 50,000 Rand. So improve the collective of the players. But important to remember that everything I'm talking about in the commercial program is in the collective. It's the player as a Protea, as a Western Province player, as a Gauteng player. You would have noticed that one of the best examples of it is probably Sia Khaleesi, who's got a number of commercial individual. He's on multi-choice, Discovery, etc. You will notice he's on those advertisements without the Springbok jersey because that's in his individual capacity. He can't do that collectively. So part of our work with CSA is we police it, because often there are companies who utilize pictures of the Proteas players in their kit, and they're not commercial partners of CSA. And we've actually taken legal action against companies for doing that, to protect the commercial program of the trust and of CSA. SACA trusts are audited annually, of course, and they're open to scrutiny, always have been. They're also presented at our AGM. I do find it ironic that I'm having to defend this commercial program because it is the envy of other cricket playing nations internationally. And we are often asked to assist. SAPA, our Rugby Players Association, they've got exactly the same model for South Africa as the Springboks, and they came and they copied our model to put it into rugby. Football like it, but with football it's much more difficult given the challenge of team ownership that exists in football. But on my footnote there, I make the point that in 2010, the Bafana team consulted SACA to try and, well, they did put together a trust to protect the collective rights of the actual Bafana team as well. So in concluding on that point, Mr. Chair, the commercial program, again, very powerful program because it benefits players. I believe that once you have scrutinized all the statistics, you will be very clear that it's impossible for us to discriminate on the basis of it. Any differentiation is actually linked to how many matches a player plays. I'd like to move on to respond to some individual submissions, if I may, that came through.
Now, you referred to this anonymous
Yes.
complaint. Well, you have seen it, have you?
I have seen, yes, it was forwarded to us when it came from the office.
Do you want to deal with it at some stage?
Well, I've dealt with it relative to the commercial rights payments. One of the errors in the complaint is they refer to bonuses. It's not bonuses. It's actually commercial rights. So everything I'm talking
wage
about,
discrimination and bonuses.
The wage discrimination part of it, Mr. Chair, I touch on it with Mr. Pangisa, but I do believe it's something CSA should deal with in that sense.
All right. Okay.
Obviously, there were a whole lot of submissions made individually where SACA was mentioned, and I've got them all listed here. I will attempt to go through them expeditiously.
Yes.
And given that a large percentage of it deals with the anti-corruption case as well, which you've heard a lot about, and a lot about SACA in it as well, I will try not to repeat what has been said there. Be that as it may, you do have the affidavit before you, and you can read that. But I would like to just touch on a few specifically public statements that need to be dealt with. And I'll start with Dr. Eugenia Kula-Amayor, whose submission was challenging for us because it did show that she had a limited understanding of the professional sport and the structures of cricket in South Africa. And some of her narratives were a bit confusing for us, which made our response difficult. I'll be straight on that. Dr. Kula-Amayor, she was an independent director in CSA.
Paragraph 38, eh?
38, 39, I'm moving on, yeah.
Okay.
She was an independent director for 6 months. We had no engagement with her, save for a meeting that I referenced in my initial submission, where she introduced the SJN to us. In that meeting, and this also answers a question of yours, Mr. July, we unequivocally put our support down for SJN, as I said earlier, and I referenced a dispute which you wanted clarity on, and that was actually between Mr. Ramela and Dr. Kula-Amayor on the issue of selection, where she said you must be directly involved in selection. And we had a disagreement on that. That wasn't actually about the SJN. I mean, her testimony of the 5th of July, she says that SACA, the union, pays salaries. This is simply not true. We do not pay the salaries. The salaries of the Proteas contracted players are paid by CSA, and the provinces pay the provincially contracted players. We do not pay salaries. In addition to that, Dr. Kula-Amayor seems to imply that we collude with the coaches on a formula so that the players get paid less. Again, that's just not true, and it fails to understand contracting and selection. She speaks of the contract fees, match fees, and commercial rights payments in the same breath. And there's an important distinctions between those income streams, and she references the formula as being relevant for all of them. The formula is not relevant for match fees. The formula is actually what I've just described for commercial rights payments. This has led me in the next couple of pages, and I will go through it briefly, but I do think it's very important information, to explain how professional sportsmen are actually remunerated, men and women, because it's unlike any other job that you might have in the world. The starting point is that every sportsman or woman has a contract with a sporting body to represent a team and participate in matches. Often a fixed-term contract, like they are in cricket. They're fixed-term contracts. And that governs the player's participation in the game. Contract fees can vary, but the match fees in terms of those contracts are normally the same for every player who plays in a match. And we'll chat more about match fees just now. That's a standard stream of income for every single professional sports person that there is. They also have a value as a part of the collective, which I've just explained. So as a part of the collective, they've got a commercial value. That's often not in the contract of employment, as is the case with cricket, as is the case with rugby, not the case with football in South Africa. That's a stream of income that comes from, in our case, from the player trusts. And that's where the players are utilized by the sponsors. They also have value as individuals, in their individual capacity, just like I gave the example of Siya Kolisi, Springbok captain. And that's very much the role of the agent in that job, where they can generate a stream of income for themselves. Within the context of South African cricket, contract remuneration for the men and women, the Proteas, that is determined in terms of CSA, and the provincial payment is in terms of what the province is. And those are those fixed-term contracts. Like I said in 42.6, 42.6 is match fees, international matches, made irrespective of whether the player is contracted or not. So a player who's provincially contracted, who plays up to the Proteas, will receive a match fee. It's not linked to his contract. As a member of the collective, I've been through that. They sets out quite clearly how the player receives money in terms of the collective. And then there are a number of individual sponsorship agreements. Just have a look next time the Proteas play. You will see the batsmen often have logos on their bats. That's an individual sponsorship for which a batsman is probably receiving money. There's only one rule in our cricket system, that they cannot have an individual sponsor that conflicts with an exclusive sponsor of CSA, and the best example of that is SA Breweries. There's concern for me that Dr. Kula-Amayor seems to not understand all those elements of contracting that make up the professional sports person by confusing the different payments that were there. Just on 44, Dr. Kula-Amayor also states the union does have an investment company. For the record, this isn't true. We do not have an investment company. And 44.2, I've never seen in this country where a union is given money really important point I wish to make. SACA receives no money from CSA. We receive no money from CSA. We are self-sufficient. I mentioned later that there are other players' associations that get grants from their boards. We are totally independent of CSA, and we're immensely proud of that. We do not get money from CSA. Sadly, the narrative which got a lot of publicity on social media and in the media of Dr. Kula Amayor has damaged the player cause. I've had to do work in engaging with provinces where there are new CEOs or new board members to correct part of her narrative, which has been disappointing. But I'd like to think that today I've set the record straight. We do not pay the salaries of players. I referenced Professor Andre Odendaal there, for whom I have great respect. He's done some great work in the transformation field. He made the statement that SACA in the past was opposed to transformation targets. I'd like to discuss that with him. Don't need to go into that further. Advocate Norman Arendse, member of the CSA board, a great servant of the game, someone who we have a sound working relationship with. A few points I want to raise on his submission. Under 49, he says we have a closed shop agreement. It's actually not a closed shop agreement. We don't have a closed shop agreement with Cricket South Africa. I think that's just an error that needs to be corrected. Advocate Arendse also states that he regarded SACA as an obstacle to transformation in 2008. I can't comment on something that's 13 years ago.
Given that I have got this task to undertake, how would I benefit from the discourse you are seeking to have with Professor Odendaal? Because you say you would wish to interrogate his statement with him further. Let's assume that comes about. Then is there a way in which I would be able to get a sense of what you deliberated upon and where you came to the extent that it might assist the shaping of the report?
I think my point was that was mentioned in the submission, that he felt in the past was the word he used.
Yes.
And he didn't really go into any detail. So it's difficult to respond to it.
No, I'd
I'd happily sit with him and say, just let me understand where you're coming from.
Yes.
To have that engagement with him.
And then how do I get to know about what the outcome of the engagement is?
I would happily come back to you on that,
Okay.
Mr. Chair.
Okay.
I will actually give Mr. Odendaal, Professor Odendaal, a call on that.
Yes, please.
Yeah. Just on Mr. Arendse, Advocate Arendse.
Just on 47, the debate on targets and quotas, what is your take on that? Because I think Afro Forum was making a point about these targets being actually impermissible in that they amount to quotas, and the law in this country has prohibited the setting up of quotas because of their discriminatory undertone, and therefore they are unlawful for that reason.
Mr. Chair, as someone who's worked in employment equity a lot in my life, and recognizing the way our Employment Equity Act is drafted around targets relative to quotas, I think it's only in Malaysia where employment equity actually links into an actual quota. Or the rest of the world, it's a target. Whereas a target, there may very well be a reason why it's not achieved. And if you think at a Protea level, the target is set, but it's not set for every game. It's set for over a season. This is what you've got to try and achieve. I've never regarded the target. I can't accept that argument, let me put it that way. I do, and it's SACA's position, that we regard the target as having played a critical role in actually transforming the game. I think it's a given that players have been given opportunities through the target. And I think the challenge of the target is what's around the target, what's the support which I touched on just now. But from my perspective, and personal and SACA perspective, the targets have been a catalyst for change. And this is now getting into a bigger discussion, and I'm trying to avoid it. If you look at how cricket has developed and how cricket develops and where cricket has come from and the socio-economic basis upon which cricket is played, cricket is unlike any other game in South Africa. The financial basis for cricket to be played is higher than any other sport in South Africa. You have to have a field, you have to have a proper wicket, you have to have bats, balls, etc., etc. So that in itself is an obstacle to the game being accessible for many people. So the challenge for us, again, everybody in cricket, is how you change that socio-economic basis of the game. Now, I think one of the mistakes on targets is that we get fixated on the target and not on the support structures to make the targets work. And that is where our argument of the commoditization of a player comes in. So in other words, I need a black African player. Let me put Mr. Roger Wachipa in the team. Thank goodness I've got an African player, I meet the target. Mr. Wachipa doesn't succeed, let me find another black player. So no one actually invests in him.
Or I blame him
He will score runs. Yeah.
for us not winning a match because he's a target.
He's a target.
Targets are,
So one of the initiatives that we've discussed, what we are currently doing, we had one yesterday with the teams, our diversity initiative, is where black African players said to us, we don't want to be seen as a quota. But at the same time, I think Cricket South Africa makes the error in a lot of their analysis of transformation is directed on actual targets and figures, saying this is the number of players. So effectively, you're not actually dealing with the individual. You're just dealing with a target.
It's tokenism.
It becomes tokenism. And that's why, sadly, in the old system, the semi-professional system, our argument of the commoditization of players is there were a number of black African players who went from team to team in the semi-professional, hoping for better luck at another team. And they just remained semi-professionals from age 20 to 28, and their career never really went, they didn't get to play franchise cricket. That's the negative of just focusing on the target. I do touch on it just now, but that argument, I don't think it's got any merit.
Yeah, well, it's a debate for another day. I don't want us to be detained by that. There's a difference between the quota and the target.
There is, yes.
The target is more favorable than the quota because what the quota does, the emphasis is on the number, that you shall have so many people. Whereas the target, you may not have that number, but you've got a target of how many people would you want to have in the team. But it doesn't mean that you are fixated on that number because the quota, the downside of the quota is that if you say 3, you can't have more than 4. I mean more than 3 because that's what the quota says you must have 3. Whereas with the target, you are not limited to the number.
Yeah.
Well, yes. Yeah.
Exactly, yes.
Okay.
Just touching on Advocate Arendse, he says he regarded SACA as a stumbling block at stage. I would dispute that. I think it comes through, and I deal with it in 51.1, which is a criticism of CSA on the targets, which you will see I set out there. We agreed with CSA that if they were going to change the target, they must consult us because it impacts the collective agreement. And an example of how you have to be careful how you change a target was in 2015 when the Board of Directors changed the target at the end of March 2015. So they increased the number of black African players in the starting 11 to 3 from 2. But they increased that target at the same time that the contract window closed. So every team had contracted based on the old target. Okay. This caused absolute widespread confusion amongst everybody because the directive came down and coaches and CEOs were not quite sure what to do because they'd actually contracted their teams based on having to field 2 black African players. Of course, it was hugely prejudicial to black African players because it meant they were going to play black African players who were not contracted. So in other words, who were amateurs. So they weren't actually going to get a contract fee, which was counterproductive if you think about what you're trying to achieve by bringing in the targets. So we as SACA, we insisted on a renegotiation of the MOU to increase the number of contracts by 1 and increase the contract allocation by, I think it was about 300,000 Rand at the time, to make sure that they could contract additional player, Black African player, who would have a contract so that they would not be prejudiced. So, you know, when someone says SACA was obstructionist, we did cause problems for CSA at that time, but it was because the Black African players were being severely prejudiced by the change. And that's where one has to think about when the change. So we have always said to CSA, if you're going to change the target, it actually should be December, because it's 2-3 months before the contract window opens. It gives teams a time to plan. That was done at the same time the contracting window closed. Mr. Max Jordan?
I see the problem there. The problem there is not so much about the changing of the number. It's about people who are told that you need 2, and you go and get exactly the 2 black players. And then you are going to have a problem, because all what you want to do is to meet the requirement.
Yeah.
Then you're going to have a problem now if now there's 3, because you don't want to take as many black people as you can.
Yeah.
You are limiting it to the 2.
I do think that will change now in the new structure.
Okay.
In the old structure, where you had a franchise team and a team below, that used to happen.
Okay.
Now, I think you've got to be much more clever about how you contract your Black African players, actually, and all your players. And that's one of the reasons why the new structure is so important, because I think it takes away a lot of those, call them contracting tactics that teams had. Mm-hmm. So you could put a number of 4 or 5 Black African players in your provincial team, and then you put them up to your franchise team. You can't do that anymore. Mm-hmm. You've got to actually have a solid team. So that is a good thing for cricket in South Africa. Mr. Jordan, he started his submission by saying that CSA had failed to deliver on their mandate, which is quite an indictment on the governors and custodians of the game, actually, if Mr. Max Jordan said that. I do think that, you know, one has to hear submissions from previous CEOs. I was hoping. It doesn't look like you're going to get to that. Provincial CEOs, national selectors, you've had some of them on, to understand the issues around contracting and selection that they've faced, because CSA has got the manpower, it's got the finances, it's got the muscle to drive transformation. That's really what their mandate is. To say they've failed is disappointing.
It's disappointing, but you don't differ with that.
No, I agree.
Right. Okay.
I agree. And I'll go on 55, where I say a statistical analysis of player opportunity over extended period does not assist in understanding why it's failed, because that also doesn't help you. And I'm going in now on 55.1 on a couple of things that were actually touched on by Doc Musaji, Linda Zonda, and Professor Fall, on some of the critical issues that we believe there need to be for transformation to actually take place properly. And the first one is what I've touched on already, level playing field. Everybody's spoken about it. I think Doc Musaji actually used the same phrase as that. Is there a level playing field for individuals to enter cricket? No, there isn't. The majority of Proteas men, irrespective of their race, develop through the top cricket schools in the country. The reality is, Mr. Chair, that the best facilities in South Africa in cricket are at probably 25 schools. If Western Province...
All schools?
25 schools, yeah, the top cricket schools. If Western Province train in winter, they don't train at Newlands, they train at Bishops. And the reason being is that it's all very well funding the establishment of facilities. The cost for cricket is the maintenance of those facilities. It costs you millions of rands a year maintaining facilities. Those schools are able to do that. I don't believe CSA can do it on their own. That's a challenge for you, sir, because I think government have to come to the party there as well. It's difficult. It's all very well going and laying a cricket pitch, but if you don't have a groundsman looking after that pitch, it's worthless after a year. The schools have got that manpower and that finance, and that's why we sit with a situation where it's not a level playing field. It's why our top Black African players are actually still coming from those schools. You mentioned, Mr. Chair, I can't remember who it was too, where are the black batsmen? I think you made the point quite correctly. And the reality is that a batsman needs a professional coach at age 14, 15, 16. He needs a turf wicket. He needs competition, which immediately places him in the realm of those schools. That's a challenge. And that's the starting point of understanding transformation in cricket, is the levelling of the playing fields. It's a challenge. It's one of the reasons why we have started an initiative on equipment, because we getting our players to donate their old equipment so we can start going to the underprivileged areas and say, at least we can start with some equipment, because that is expensive. If you look at those 4 foundations, the second one is affirmative action measures, if you're going the equity way, and that's the setting of the targets, which we've discussed. It's critical in transforming the game of cricket, as I said. But if your level playing field isn't in place, it's hamstrung, because how the players coming through the system. So you can't just focus on the target, because you've got to make sure you've got a level playing field so players are coming through the system. That's a challenge. Third point I make there is the setting of the target in itself isn't sufficient, because otherwise we have a situation with Mr. Wachipa here. You actually need to develop that player. Otherwise, if you just leave him alone and his career goes nowhere, he isn't developed. And I think a lot of the criticisms coming through from players in this forum relate to this. Where did someone sit down and actually manage me? Which is why we have, it's happened at Proteas level, is our whole player development plan process that we are insisting happens at the provincial levels, where actually one sits with Mr. Wachipa and says, this is your career plan. So it's no longer a commodity. There's got to be a plan behind the player. Otherwise it fails. And there are too many players who've just fallen by the wayside, been a target, and there's no development and training. I think Ms. Dove, in her submission, focused very heavily on that type of development, and that's also a lot of the work we do outside of the field. And fourth is managing the diversity. The establishment of diversity does not in itself bring about a transformed team. And Mr. July, one of the questions you sent through is, what are the learnings from BLM that SACA had? And one of our learnings was that, you know what, you can't go look at a team and say, oh, great, that team looks transformed. It doesn't actually mean that there's diversity there. You actually have to work at the diversity, which is why the players have set aside R1 million for our diversity initiatives. Yesterday, we've had our 4th team go through it. We started in September. We're now on our 4th team. And that's the hard conversations happening about, how do we manage diversity within the team. So if you're not ticking all 4 of those boxes, you're not going to succeed in transformation.
Now that we're talking about diversity in the team, is it not relevant to the kneeling issue that is happening now, where the almost all white players refuse to take the knee, and only when the CSA gave instructions, and even then there was one, which is Quentin de Kock. So in all of this, as SACA, that you are doing, what do you, how can I put it, when you see, because I understand you to say you take them through training, diversity culture, training, when these things happen, what is SACA's reaction to things like that?
That is something I'm currently dealing with, so I want to be cautious on how I respond to that, because it's actually a situation at the moment, and my meeting at 4 o'clock is actually about that. So I do want to be cautious of it. But let me start by saying this. I actually agree with the position of Dr. Musaji on this, that my preference would be that there was a uniform approach to the taking of the knee on the Proteas team.
What is current, though, is what they've done now.
Yes.
But they have not been taking the knee.
They haven't taken the knee throughout. For 12.
So that's where now this cultural diversity of where does
what I can say about the Proteas team is this Proteas team has probably had more culture and diversity engagement than any other Proteas team ever has had. And specifically under the leadership of Themba Bavuma and Dean Elgar, they have had the hard conversations, because I'm aware of that. I've had that engagement with them around diversity in the team and players' understanding of BLM, players' understanding of taking the knee, and players' understanding of what it means to be in a team with diverse cultures, diverse races. And it is actually probably the most diverse Proteas team we've had. I think the disappointment of where we stand now is that this issue probably should have been dealt with a while ago, and not by the board at an ICC event where it's now front of house and is a crisis, basically, because it is a crisis which we have to manage. So they have not taken, some players have not taken the knee since December, I think was the first time. And I think it should have been dealt with back then, and we wouldn't have a crisis now. From a SACA perspective, I would like to see the players have a uniform approach to taking the knee. But at the same time, I'm not going to instruct a player to take the knee on that same basis. I'm hoping we can have a good solution to this, and the work that's currently being done, that I'm involved in. But yeah, I do think, I feel sorry for Themba Bavuma because he has done incredibly good work in managing that team culture around diversity. And I think his press conference yesterday was excellent in dealing with the issue as well. I will be critical of Cricket South Africa because this isn't a new thing. It's been around a while. I don't think it should have come up at the World Cup. Let me put it that way. Yeah, but it is something that's been managed at the moment.
Well, while sharing it, I mean, it's quite topical, and I've been refusing to say anything to the media whenever they have been calling me about Queen de Kock and what. The question I want to know is whether it is so that there was a racial divide to this taking of the knee in the Proteas team. In which case, then I wouldn't understand why Quinton de Kock is being targeted as having been the one who refused to, or who was vocal in saying he's not going to take the knee. Or is it only he? What is the historical position? What is it now? What's the position now? Is it only he who has not heeded the board's recommendation? Well, it's instruction actually.
Yeah, he did not heed the instruction on Tuesday when they played. Yesterday when they played. Yeah.
Okay.
He's the only player. Yes.
But the other white players did.
They did take the knee. Yes.
Okay.
Yeah. Yeah, like I say, it's a situation that's currently being managed.
Yes.
Last point on managing diversity, I think it's a conscious process of managing diversity. It's not something that just happens. You don't just put a group of different people in a room and everybody sings Kumbaya. There's a conscious process. And that's why it's important for us to be involved in that space as well. I would respectfully submit, sir, that any outcomes of this process have to focus on those four areas: the levelling the playing field, the target, the actual development of the player, and the managing the diversity. And what we've done as SACA, we've taken that and we've looked at where can we actually add value now. And that's why we've got the equipment initiative, why we've got the diversity initiative here, et cetera, to try and actually be constructive in this space. Because otherwise it won't succeed.
Mr. Britsky, where does the playing opportunities fit in these four key foundations you've added?
It actually fits in the setting of the target and the development and training. So one of the problems and one of the reasons why we put forward a player development plan for each province is I contract Mr. Wachipa and I say, welcome to my team. You're going to get paid 500,000 Rand a year, and we're looking forward to having a successful season. And the season starts and he's training. He doesn't get in the first match. Okay. Doesn't play the second match. And he now starts wondering, so what actually is my role here? Where is my playing opportunity? What we want to see, and I would respectfully ask the Ombudsman to almost insist that the teams do these player development plans, is to say, listen, Mr. Wachipa, you're the number two batsman in our pecking order. You're not going to open every game. But what we're going to guarantee you is a minimum of 8 games this season. Okay. If you play well, well, you're going to get more than 8 games, but I'm going to give you 8 games. And this is what my expectation is of you. I expect you to average 35 this season. And future contracts are going to be dependent on how you perform relative to those. Let's say he's averaging 45 at the end of the season. He can sit down and say, well, I met your minimum standards here. I've actually done quite well. Or you got 20. They say, well, you know what? Our performance criteria was quite clear. You've played the 8 games we said we'd give you. Hasn't quite worked. What's gone wrong here? Those conversations aren't happening enough. And that is about playing opportunity. So a player says, Mr. Ramela says, he didn't, in his final season, he wasn't aware of what they wanted from him. That's wrong. You should be sitting down and saying, you know what, there's a new kid on the block here.
Right from the beginning.
Exactly.
Yeah.
Players want certainty and consistency. Whether it's in selection, whether it's in playing opportunity. So when I speak about development and training, the development of the player, that's the development of what I expect. The perfect scenario is when I don't give him a contract, he should say, I know why you didn't give me a contract. I averaged 10. And we're quite clear.
And it's not because I'm black.
It's not because he's black. And that's the problem. So your playing opportunity comes into 2 and 3. Is the target and actually achieving and what is expected of the player. What is his actual development plan? If we can get that right, we will take a lot of the negativity, bitterness away from how players move in seasons and things happen. You know, a player gets injured, changes that dynamic. But that's why that is an ongoing process.
Is this what you guys are planning to?
No, so we when the restructure took place in March and we consulted, we insisted on there being a player development plan in the player contract. So that's now in the player contract.
Okay.
But the next part is compliant.
We being
SACA.
In SACA.
Okay. The next part of the question is, which you can quite rightfully throw at me, is how am I going to enforce that? And that's something we have to do. It would be wonderful if the Ombudsman could say, my recommendation is to have these player development plans. It will help me a lot, sir. Because if a player knows what's expected, it's no different to any employee in a company in that regard. And that hasn't been happening. That's a generalization. It does happen in certain, but generally that's why players become unhappy. And then they leave and they don't know. So that's where it fits in. Just a couple of points on Miss Mary-Ann Dove. Well known to us. She does a lot of good work in research. And a lot of what she spoke about, I'll let one read it, there's around the commoditization of the target. It's really what she put out. Interesting.
I'm surprised you've got a response to him when he had shared a lot of good things to say about SACA, except for the management.
She said we were too white, yes. There are 2 points. Yeah. So I've got a few things to say.
Some truths have to be told, Mr. President.
There's one interesting point. She did make a point that black African players were paid a premium about 5-6 years ago, which is true. They were. And CSA came out...
But let's qualify that. She was talking about the provincial.
No, she was talking about the provincial.
Yes.
Sorry, I'm talking provincial, not Proteas. You're correct there. It wasn't Proteas. The Proteas is a clear structure.
Yes.
CSA came out at the time and said they wanted to put in place a ranking system for players at provincial level to stop that premium being paid. That it should just be cricket reasons that a player is paid. So a ranking would be, you're a number 4 player, you can get 500,000 Rand, and that's your cricket value. We opposed that vehemently, and we said no. If a player's value is based on his playing ability and his race, that's the market. The market must dictate what's going ahead. So we came out quite strongly against that, and they never did do that, which was correct. Ms. Dove is also correct in saying that premium has now fallen away in the last 2-3 years.
In fact, it was wrong.
Yeah.
Because it was paid to keep a black person not to move.
It was. You see, it creates a imbalance in the market. But fortunately, with the increase in the number of black African players specifically, that's gone. I will touch on her statement that the management was white, and I think maybe that was correct when she did her research, was a few years ago. But I do say here that my head of communications is a black African female. My head of legal and player engagement is a black African male. My head of commercial is a black male. My head of player services is a white male. My accountant's a black female. And I, the CEO, am a white male. So I do think it has transformed, consciously so. And Mr. Wachipa, specifically with his knowledge in sports law and work, works with the players and has a very good rapport with all our players, and was part of that transformation as well. So also transformation is a key performance area of mine relative to my board. So it's something that I'm
both of you, the reason why you are here without lawyers, you are both lawyers.
A lawyer who represents himself as a fool as a client.
But that's the thing, you are not representing yourself. You are representing...
That's one of the first things I learned, sir. So you're telling me I'm a fool, I'll tell you. Yeah.
Mr. Britsky, can you just also give us the remaining 4 positions at SACA and the racial, the demography of the other 4 positions?
Other 4 positions, white female, white male, black female.
Can you tell us the
male.
positions?
Sorry.
Sorry, can you just tell us the positions?
Help me out here, Bright. Nandi's receptionist.
Tessa is admin assistant in player services.
White female admin assistant, yes.
Rowan is the
dual career specialist. And Stephen Cook reports to Brigé as a
cricket
player
operations.
development, cricket engagement. Yeah, that's 10, I think. Yeah. Moving on to Mr.
No, Advocate Mela just wants to make sure that the other black people are not people in the fields cutting grass and whatever.
No.
Numbers of stuff.
We're not very wealthy. We've got a small staff that has to do what we do. So, I want to touch on Mr. Pangiso because he raises some important points, and I'll go through it briefly. I've mentioned to you the PPP figure, which is the total cost of the player pool. It covers the contracts, it covers the match fees, which we'll touch on now, series win bonus, commercial rights, and that over the 4-year period is 565 million. 23.1%. That's 23.1% of CSA's defined revenue, and I'll explain that more. It gets quite complicated. I'm going to try and be simple. For the 4 years, so that's 565 million rand, covers all the player cost of the Proteas and the domestic teams, and that's 23.1% of CSA's forecast revenue. Player cost being a percentage of forecast revenue is a common process throughout the world of cricket in different cricket players, cricket playing countries. The match fees form part of the PPP. Okay. They are paid by CSA. I just want to clarify that there was some confusion. They are not paid by SACA. They are paid by CSA. And the match fees are actually reflected in the salary advice of the players. If you go to ACB 5, that annexure of mine on page 142 of your bundle, you'll see that's actually an annexure to the Proteas men's contract. And there it sets out, for example, the term of the contract, the retainer, cell phone, match fees. And there you see the match fees listed for tests, ODIs and T20s. Series win bonuses, etc. So that's part of the contract. That's my point I'm trying to make here. Match fees are just one of the streams of income that a player has. Interestingly enough, a Protea player probably has about 12 streams of income that make up his full remuneration in a year from different sources, which can be quite complicated for the player, be it private stuff, but that's the nature of a professional sports person. Just on the match fees debate, I actually think it's a bit of a storm in a teacup to a certain extent on the discussion. Historically, teams used to appoint one player, the 12th man, and he would get 50% of the match fee of the players who played. That, as squads increased, as teams toured a bit more, squads increased, so the number of players increased. And every time that's happened, when players have come to SACA and said, can we renegotiate the match fee situation? We've added in. So when Mr. Pangiso references there that he went to the senior players came to SACA and said, listen, the squads are getting bigger. Can we negotiate a new match fee? Now, remembering we've got a set pool of money, so we've got to move the money around. So on Mr. Pangiso having gone to the senior players, we did actually increase match fees. We've actually done it again in December because the players came to us in December, and because the squads are now bigger because of COVID, because everybody's got to be in the bubble, there were more players in the squad. So now there are 3 match fees that are covering players who are effectively outside the starting 11. And that, by the way, is standard across the world. Every country's got a slightly different variation on what they do with the 12th, 13th, 14th man in terms of a percentage of the match fee. So the allocation of match fees, it's driven by the players. And a month ago, I had a meeting with the Proteas team, and I said, guys, the issue of match fees has come up at SJN. So when the World T20 is over and we have another meeting, we need to put it on the agenda because we need to discuss it again, what their position is on match fees. So it's not something that's cast in stone. It's something that's variable. It's changed over the last few years as the squads have got bigger, and it's something that's internationally managed like that with other teams as well. They've got their own systems on how they manage the match fees. So, quite a lot was said about it, but I do believe
I can
it's...
understand the other countries. Maybe they don't have the same dynamics that we have. Because if the match fee is going to be dependent on the views of, largely, on the views of the senior players, and then the senior players happen to be white, then those 12 men downwards, and all of them, most of the cases, are black, then it becomes a problem because it becomes a color issue. Whereas in other countries, you may find that this issue of transformation is not even in the cards. It's just players. So in our country, we have this problem where now the match fee, I accept that's how it is done in other countries, but it may not suit how you do it here. I'm not suggesting that I've got a way of how you should do it. That if your senior players, at least now you've got your Pavumas as senior players, in the future, but not now, you are talking about may be something that...
It might be relevant, yeah. I hear you. I think the objective of the match fee has always been is to try and at least that all players get 50% of a match fee going forward. That's almost why it's changed. But I accept your point that senior players are now actually black African players, so it might be relevant, but I can understand that argument. Just on player contracting, Mr. Pangiso, in response, the player contracting, it's driven by the market. The player skills, player performance, transformation, format importance. We constantly provide contract advice to players. We're actually developing a contracting module to actually do that as well. And that is the excellent work that Mr. Wachipa does with Mr. Stephen Cook, helping players in the contracting. But like I said, we don't contract for a player. I've been through that. I do provide some information there on CSA's change to the domestic structure, which I won't go into because it's just background, which I think is important to read. But the allocation at the moment for the first division teams is 8.9 million rand per team for a maximum of 16 contracts. That's the allocation. And the minimum contract being 343,000 rand and the maximum one just being over 1 million rand. So those are the parameters in which contracting takes place for the Division 1 players. In 2021, Mr. Pangiso did approach SACA. He believed he'd been unfairly treated in the contracting, and we immediately said to him, if there's unfairness there, as with other contract matters, we will take them on. We're happy to do that. It's what we do. And Mr. Wachipa engaged a lot with him, and we looked at the case. We offered even to get an external counsel to look at his facts, but we were not able to determine that there was a legal basis for his unhappiness. It was more of a bad negotiation by both parties than it was a legal basis. But we assisted him to lodge a grievance because he wanted to make a point on how he felt hard done by. And that meeting was convened on the 25th of March with Mr. Peterson, also representing Mr. Pangiso there. He eventually did sign a contract to play with Northerns for this current season. We have undertaken a comprehensive analysis of all the contracting for this past season, and that was also in response to Mr. Ramela's email, which is Annexure ACB 15, alleging unfair discrimination. That was quite a mammoth job, and it takes every cricketer's earnings, and we've broken it up into percentages across race. And again, we're more than happy to sit down and share that with you, so you can see how contracting happened in the last season. And we've shared that with Cricket South Africa as well, and it's important information to see what their trends are. Of course, in a new structure, what's going to be interesting to see the trend next year and the following year, because then I think you can start getting a picture of how contracting has taken place. So, Mr. July, maybe when we come up to Vaxmans to do the commercial rights payments, we will happily show you that document as well. It's very comprehensive. and very useful to actually see. One of the outcomes there, interestingly, is, and there are a lot of outcomes, is 9 players had a reduction in contract remuneration. 3 were Black African, 2 black, and 4 were white. That was just a snapshot of, because there was a belief that Black African players had lost a lot of money in the contracting, and that wasn't actually the case. But we'll happily let you go through all those figures to have a look at that. And there I've made the point of our module we've developed, where we're going to help players on the contracting issues. Like I said, contracting happens with agents, but there are agents and there are agents, and that's a challenge for us as well. I'd like to move on to Mr. Lonwabo Tsotsobi. But before I do, I'd like to actually say something quite personal. It's obviously about the corruption investigation. And I have never wanted to actually speak on the corruption investigation. It's very difficult to me to speak about it because it was an immense amount of work. It was a difficult time for cricket in South Africa, and the statements made by players on the Marawa show and effectively at the SJN have been difficult for me personally. And I don't believe anything can be gained for these players by engaging in these narratives, because the players are still at risk of criminal prosecution. And last year when they made statements on the Marawa show, a number of people came to me and said, you have to go with a reply because they've made dishonest statements. And I said, no. I said, we won't do that because it can only harm the players in terms of their own well-being and possible criminal prosecution. But given that they've come to the SJN and made these statements, I'm really left with no alternative. I'd hoped, in the words of Cicero, that time would obliterate the fictions of opinion, but that has not happened. I hoped it would not take place. I will go through this briefly because I know that Mr. Cole and Mr. Becker have spent a lot of time going through the corruption case with you. And I have no knowledge of the merits of those cases. I heard them for the first time at these hearings, as to the extent what players have done. The video you saw from Mr. Cole, first time I've seen that video. Very difficult for me to watch as someone who works for the players and the well-being of players. But I do need to say a few things about it, and I will try and be brief.
Yeah, as I said, I think I did mention it to both I think Mr. Cole and even Msaji. The only relevance for me for all these match fixing allegations, to what I understand my mandate to be, is the extent to which there will have to be a case made that the wrongdoing there, whatever it was such that I can, in the end, come to the conclusion that those who were targeted by allegations of being involved in match fixing were dealt with manifestly on the basis of their race. Because that is the mandate that we are charged with, is gender and or race discrimination manifesting itself unfairly in the activities at Cricket South Africa, whether it's on the player level, selection level, and whatever. I will not stop you because it's now so much out of my hands. Because even with the players, I sought to communicate that, there's a time and a place. And as I understand, my mandate This is not the place for people to come and talk about match fixing. I had even forgotten about match fixing because I thought the Ansi Cronje saga had dealt with it. But it appears that it is something that goes on and on. So, and I was alarmed in the most recent hearings when almost half of the presentation to us was giving chapter and verse of the minutiae of what actually was done by whom. And as you say, there was even a video clip. And I sat back and I continued to ask myself, where is this going to at the end of the day? Where? Because I think match fixing, whatever it was, is a subject in and of itself. And I am not sure to what extent it assists me. But it would be unfair of me now to stop you from dealing with those aspects, but perhaps to the extent that the players themselves dealt with match fixing in a way in which you feel it calls for response. But let me be very clear. My prima facie view is I do not see that match fixing as an issue and an event where chapter and verse said, I met so-and-so and such, and then all of that, if it will not in the end say there was no racial bias here, there was no gender bias here, or as the as the players sought to communicate to me, we were targeted. And there was a false claim that, we were involved in match fixing simply because we're black players. Then to that extent, but I think it's a runaway horse that I'm now not able to stop. It should, in my view, it's not part of my mandate.
Maybe I can try and tame the runaway horse slightly. You have my affidavit in front of you. It provides extensive information on corruption. It's 150 billion rand a year, $1 billion a year industry in India, and this investigation was one of the most serious in world cricket. That's the bottom line, and I go into great detail there about the threat, about the criminal process, about our education and training that we've always done for players, that we continue to do for players, that we constantly are getting reports from players. Either myself, Mr. Wachipa, or Mr. Cook will get a player come and says, I've been approached on Facebook, help me. So it's a real threat that we deal with on an ongoing basis. So the education of players is critical, and how when this broke, when the initial whistleblower came to me, the actions we did on going to every team, warning every team that apparently this was going on. We even had, I mentioned it there, the PCA, which is the English Cricketers Association, came out with one of their members who had served jail time to actually speak to players and say, this is how serious this is. So I'll skip through. I won't go into that. You can read it. I think it's very interesting. Just dealing with Mr. Tsotsobi, who's actually claiming unfairness, that we treated him unfairly. I will touch on that.
Yes.
And I'll start by saying at 79, we've always had a very good relationship with Mr. Tsotsobi. He's been a very active member of SACA, even after he left SACA. We've assisted him in managing a number of personal challenges, and I won't go into them there. I list that there, and assisted him in other matters as well. We even assisted him after his ban from cricket, where he required professional assistance, and we funded that. So we've had a good relationship. Mr. Van Wyk has had engagement with him in the last 3 years on what he wants to study. We'll be willing to assist him as well. That's after his banning. So we've had a good relationship. So his statements when they came out were shocking for us. His statement that SACA would be representing him in the anti-corruption charges is just incorrect. We were never going to represent players. That call had been made early on because we had whistleblowers and we had accused players. There's a clear conflict for us. We also realized very quickly players would require external legal representation. To state that we'd taken a position regarding his participation, it's just not true. We were unaware of what charges players were facing. We were unaware of the merits. So how could we, in any form, make a judgment where he says SACA had already found me guilty of match fixing? It's difficult to understand that, and it's difficult for me to read it. Mr. Becker was not a lawyer for SACA in 2015. I think he probably clarified that. He was CSA's lawyer when CSA got it legal. He's one of the best sports lawyers in Europe and South Africa. We were very quick to snap him up as a consultant in December 2019. I go in paragraphs 82 onwards is to internally what happened at SACA when this broke. We sat down and we created our own protocol how we were dealing with this, and I've listed it there. And one of the things was we would not represent players, but we would source attorneys for players who needed attorneys. And we got Joburg, Cape Town, PE, the main centres, to a law firm in each centre who we were going to refer players to if they needed it. And we were going to assist them to make appointments with them. And we were going to assist with, initially we said, with the payments up front, deposits. We adhered to all those conditions, except we ended up paying significantly more because it just became more expensive. And sadly, some of the players perjured themselves, and so they had to redo affidavits, and we continued to support them financially. The process unfolded where we would get a call from Mr. Cole and say, we need to interview this player, or we've seen this player, and we would then engage the player and say, you need to get legal representation. It was as simple as that. And we offered the player, we told the player he had to get legal representation because the consequences of this were serious, criminal consequences as well. If the player did not have his own legal representation, because some players had attorneys, then we said we can refer you to a law firm. To say that we forced players to certain law firms is just not true. We did not do that. I'm an admitted attorney, practiced for 15 years. I'm not stupid to force a player, and a lawyer must act in the very best interests of his client, not in the best interests of SACA. We did not instruct attorneys, and we offered psychological support to all the players as well, including Mr. Bodie, who was a past player at the time. Mr. van Jaarsveld was represented by Shepson and Wiley in Durban, Mr. Peterson by Robin Twaddle attorneys, Mr. Symes, Belati and Machikwa by David Woodhouse at Tabaks, Tommy Tolikili by Lawrence van Sale. There were a number of other players who also went to attorneys, but they haven't been mentioned. I'm not mentioning them.
Mr. Bretzka, on what basis did you... I'm sorry, I'm maybe misunderstanding what you're saying. In terms of Tabaks attorneys, did SACA recommend Tabaks attorneys to the players?
We effectively identified a law firm that was not one of the big five, and that was from a personal service and cost perspective. I don't know Mr. Woodhouse at all. And I had contacted him and said, would his firm be interested in representing players who were implicated in this? And then effectively, and you'll see it in one of my annexes, I asked the player, do you have an attorney, or do you want me to refer you to an attorney? And if he said, I don't have an attorney, whichever region it was, I said, Tabaks Attorneys is a law firm we've spoken to. You can go there if you want. And I gave him the details for the player to actually make the appointment. So you'll see in the annexure that I sent through to, I think it's Mr. Belati's one there. I give him the details of Tabaks and say, if you want to use this attorney, use the attorney. He's not forced to use an attorney. He could go to any attorney he wanted to.
Okay.
And
so, but Tabaks attorneys were the attorneys that it was the only firm that you had.
It was the one
suggested.
firm in Joburg, yeah. So there was a firm in Cape Town, Shepson and Wiley in Durban, etc., like that, yeah.
No problem.
Mr. Tsotsobi was never referred, by the way, to Tabaks for the simple reason that I never spoke to Mr. Tsotsobi throughout the entire saga. So when he says that SACA indicated I should use, if I want to use TGR services, I would have to pay the legal fees out of my own pocket. It's just not true. It's just not true. I had no conversation with him. We did not appoint Mervyn Tabaks attorneys as his legal representative, and we wouldn't have instructed them anyway. I was not even aware of the fact that Mr. Tsotsobi was represented by the attorneys in Port Elizabeth. I only learned that now after the case. I had attempted to contact Mr. Tsotsobi a number of times, but I couldn't. So I asked Mr. Cole and Mr. Becker that when they speak to his attorney, to please tell his attorney that we will assist with the legal fees. And that, I think Mr. Becker gave an indication of that. It's very in detail. I actually give the transcription where Mr. Becker and Mr. Cole tell Mr. van Kerkhoven that SACA will assist with the payment and he needs to get hold of SACA. And I never did get a call from them. There was no payment of Mr. Tsotsobe's legal fees because we never heard from TGR. If Mr. Tsotsobe's narrative is to be believed, then why did Van Kerkhoven have no idea when he was consulting about SACA? Because in the transcript clearly says, he says, who SACA, what are they doing, what are they willing to do? He has no idea of it. So there's no logic in what he says in that regard. Similarly, I say in paragraph 84, SACA was never approached by Mr. Tsotsobe to assist in retaining TGR. There's no logic. Van Kerkhoven was well aware in April that effectively we would assist. Otherwise, Mr. Van Kerkhoven needs to answer as to why he did not tell his client material information. And likewise, Advocate earlier, when you asked Mr. Tsotsobe who at SACA was insisting on that firm, he's actually not able to provide a name. He references back to David Becker, which makes no sense. I did not have a conversation with Mr. Tsotsobe throughout that entire saga. So it's very disappointing to have a fabricated narrative on the representation issue. All other players we paid legal fees for. Why would I have not paid for Mr. Tsotsobe? We offered it to his attorney at the time. It's very difficult given the many years we've supported Mr. Tsotsobe in our services and that he's been dishonest under oath on this point. It is difficult for me to deal with it because of the extent of that dishonesty. Mr. Peterson, he had his own personal attorney, Mr. Twaddle. I don't want to deal with that in any great detail, save to refer you to Annexure ACB 13, which is an affidavit of Mr. Tony Irish, who deals with that issue of the initial conversation. It's probably relevant in terms of the context of the corruption case in that Mr. Irish explains the content of that meeting, but that is goes to page 160. But again, I'll allow you to read that. It deals with Mr. Irish's affidavit relative to that meeting on the 8th of October that has been dealt with at length before.
In what remains, I would love you to focus on issues that relate to transformation to the extent that we have dealt with them. As I say, I don't think after the extensive coverage of this whole anti-corruption investigation, there is a need for us to spend any more time on it further than you have done on your sworn statement. And I clearly see my mandate as being one to address issues of transformation on a race and gender basis. But I've got your sworn statement, that is evidence, by way of affidavit. I don't think you need to spend any more time on this whole anti-corruption and match fixing and what have you. And especially to the extent that you have indicated firmly that, first of all, some of the facts that were put before me by the players were misrepresentations, and you deal with that in your affidavit under oath. But more particularly, you feel that,
Thank you, Mr. Chair. I accept that. If I may just go to then paragraph 108, which is my almost concluding points on the corruption stuff.
Yes.
They're almost my final points to try and put a full stop on the entire thing. And then maybe I can just briefly go through those. They're brief. I need to say that the players who admitted guilt committed the most egregious offences in the world of sport. They betrayed their sport, they betrayed their teammates, and betrayed the public. Subsequent to the conclusion of this matter, SACA, we attended the FICA AGM, and we presented to all the other players' associations on how we manage this by assisting players. And it was regarded by all of them as excellent and actually the benchmark that other countries will follow for players' associations if their members are ever found to be in the same predicament. 108.3, I've reviewed how we approached this, and I actually believe it was an excellent approach. We offered financial support to the players. We made sure they had legal protection, and they had legal protection of the highest level. We offered psychological support, and in some ways we went beyond in trying to assist these players. Like I said, despite these players promoting a dishonest narrative on this, we haven't gone out in the public because I don't think it's in their best interests. I do believe they have challenges facing them from a criminal prosecution point of view. Interestingly, Mr. Chair, at the time of the crisis, our greatest concern was the fact that we spent over 450,000 Rand of player money, which is normally money we'd have for bursaries and player education, to pay the legal fees of players who, by their own admission, had committed offences. Our concern was that other players would be upset with us. And in subsequent education and training sessions we've done with players, players have taken us on. They've taken the view, why did you pay this money for these players? They betrayed us. So that, ironically, was our initial fear. I also need to say, and this is not, I'm not throwing a stone at the SJN, but over the past few weeks, we've urgently had to redo anti-corruption training. So Mr. Cole does his training, we do our training. Because the submissions that have come through on Marawa and at SJN have undermined the seriousness of anti-corruption in cricket. And when I say we deal with, on a weekly basis, a player coming and saying, I've been contacted on Twitter, I'm worried. And we have to report it and make sure, and often there's nothing to it. Our players are again being targeted. We in South Africa, sadly, are regarded as an easy target for corruption in cricket because of what's happened. So the bookies see us as easy. And we are battling to get rid of that label. So Mr. Wachipa and Mr. Cook have actually just finished going to every single team to do anti-corruption because we're so concerned about the narrative that's come through from SJN, from players who speak a lot about it and say it wasn't fair, when actually we need to say, guys, this is a really serious issue we're dealing with. So those are some really important
not all is
points.
Lost for what came out, but I was just giving you my knee-jerk reaction, my prima facie view. But rest assured, like I was trying to assure the two previous witnesses, we have it on under oath. It's in affidavit form, and to the extent that I might have to say, I can't write a comprehensive report and conclude it without touching on this subject. But I'm not going to spend a lot of my time when my gut feeling, which may end up being my feeling in the end, is that this does not pointedly address my mandate.
Well,
but as you said, I allowed a runaway horse to get out of the stable. Just assist me in making sure that, in it running away, there are certain aspects that my attention needs to be drawn to the extent that the players themselves put certain things on my table. If taken on their word, I would be misled because they were either untrue, the allegations were untrue, or there is a nuance that I must speak to their, to the allegations. That I will, I obviously can't ignore it, but take it from me, no amount of me being told orally how irrelevant this match fixing thing. It's actually a red herring. It's taking me off my concentration on what should be my mandate.
I would wholeheartedly agree with you. I with respect, believe it undermines some of what I believe is good work that has to come out of this.
That's the thing.
Exactly. I will refrain from going through all of my affidavit when it relates to the anti-corruption. I suppose I'll strike an agreement with you that if you read something where you feel you need to come back to me, you'll come back to me on it. Then
No,
we can be happy. Yeah. So just excuse me that I might jump around slightly in terms of continuing. But if I can just, Mr. Etienne Belati, obviously there's a corruption element to that which is there and you can read it, but he makes a number of other statements which I need to deal with which are on point. If I go to paragraph 92, he makes a statement, he says SACA's a sweetheart union. He references us, and I just have to say that's just not true. I list there the numerous disputes we have had ongoing with CSA over the past couple of years. You can read the Fundudzi report. I give you a good reference to it. At the bottom there, it's online. You can review our court papers under the Gauteng local division to see the extent to which we've been at war with CSA over the last number of years. It was the players who, through SACA, and I mean this when I say it, stood up for what was right in cricket and I believe brought about change for the game because cricket was in dire straits. It has been in dire straits for the last number of years. And we incurred significant legal fees in the process of doing so. On an ongoing basis, we engaged in disputes with different employers, fighting for the cause of players, and I've mentioned a couple of them. SACA, we fought with CSA on them stalling an MOU 18 agreement. We took CSA on how they dissolved the 2017 Global League and got a really good settlement for players. And likewise, when they failed to honour the commercial agreement for the MSL in 2019. So to say we're a sweetheart union just doesn't accord with the facts of the last 3-4 years, where it's been emotionally draining the extent to which we've been at war with CSA. And actually the last 6 months is the first time in the last 3-4 years that we actually probably haven't been at war with CSA. So I can't accept his statement there. Mr. Mulati also says that the Proteas are favoured. That's also not true. The majority of work undertaken by SACA and our budget does not relate to the Proteas. It relates to domestically contracted players. It's not focused on SACA, and our PDMs who work at the ground level in each region actually are dealing with the provincial players. Mr. Belati goes on to say that SACA is at the heart of pay discrimination. I find that offensive. It's just and makes no logical sense. He says, and SACA is controlled by white people. SACA Executive Committee is a diverse group of people. It's not controlled by white people. I don't control SACA. My executive controls the strategic direction, and they are a diverse group of individuals. We don't pay salaries. We don't negotiate salaries. We don't determine the value of salaries. It's not possible to be at the heart of pay discrimination when actually it's the MOU that creates the framework that protects from that exactly happening. Yes, ma'am.
Sorry to interject there. Mr. Britzka, have black players that are currently part of SACA complained to you or complained to any other relevant person at SACA about pay discrimination? Have black players, has this subject been brought up to SACA?
It's probably come up in the last year more than it's come up before, and I think probably in light of BLM, it's come to the forefront. So Mr. Pangiso coming and saying he feels he's been unfairly treated. But having said that, if you, which we will show you, look at the analysis of player contracting for this past season, you will see that some of the highest earning players throughout the country are black African players. So I'd have to say no, not in any. It's more a case of a number of players come and complain about contracting, not necessarily black African players. It's players across the board say, I don't think I got my right value in the negotiation. And I don't think we could say one race was more than other races on players who are disappointed in their contracting. I will actually defer to Mr. Wachipa, who deals directly at grassroots on that. Is that a fair statement, Mr. Wachipa?
Yeah. Because, sorry, Brigitte, for your answer, because what I want to understand is, which I don't really get from your affidavit, like, what type of issues, like, does SACA deal with when it comes to black players, and maybe what issues does it deal with when it comes to white players? You know, because want to understand, like, are these issues only coming up the first time because of SJN, or has SACA dealt with some of these racial issues?
I mean, forever and a day, we deal with contract issues. We deal with players who are unhappy about a specific issue of their contract. That's been ongoing. We on an ongoing basis will have players who are disappointed at losing their contract. That's not a new thing that's happened. What you will find is that when we do exit interviews with players, a player will say, you know what, I don't really think I had a fair career, you know, which happens after the fact. As a player is trying to make it. It's not something you hear about while the player is playing. That's quite a common thread you will see, where a player says, you know what, I wish I'd done better. I should have moved to another team. I should have done this, etc., etc. But issues that arise for players on an ongoing basis, be they disputes, or we've had players file grievances against a coach. You know, all players in a team. We've had those type of disputes as well, where they're collective disputes with players. It's cut across race in that regard. I can't say that, in my experience, it's been specifically black African players or white players in that regard.
What issues don't cut across race that SACA deals with?
So in other words, issues that are specifically race-based.
That's correct.
I'm finding it difficult to answer you on that, just on the spur of the moment, if I can think of a specific race issue that's arisen. I haven't had a player come to me and say, I should have been chosen in the team because I'm black African and I wasn't. I haven't had that type of race issue come to either of us on that basis. We've had a race issue that we've dealt with around accommodation. Okay, that would be one that I can think of a few years ago. We were unhappy with the accommodation certain players were getting, and those players were black African players. And we resolved that. So that would be, I think, a specific race issue, where players are coming from outside an area which is not traditionally a black African area and come in and their accommodation isn't actually consistent on the standard. We've dealt with those issues. That would be an example of a specific race issue, yeah.
Okay, no problem.
Sorry, getting my spot. Paragraph 94, Mr. Belati referenced financial assistance, which he didn't get, which he said a white player got. Our process for financial assistance, it's reviewed relative to specific factors. Mr. Belati did not receive financial assistance requested, but would have been referred to our player services department to an independent financial consultant for assistance. That's a starting point for every player. We don't just give a player money if they're in financial difficulty. They must go to a financial consultant to try and assist them. We assess it thereafter to see whether the person does get financial assistance. And players do get financial assistance. You would have recalled I referenced earlier players who is in litigation because of financial difficulties. We not giving him the financial assistance, we've sent him on the same basis to an individual to assist him in that regard. So that's the process we follow for every single player who's in financial difficulty, and there's no race basis for that. SACA, under paragraph 95, I'm responding, it's a transparent organisation. Our annual financial statements are open to all players. We present them at our AGM, and players are able to query money they receive from the trusts. Again, Mr. Belati makes a statement that the commercial rights payments are unfair, and again, we'll give those all to you so you can actually see those payments. The Provident Fund was mentioned. There's a SACA Provident Fund. It was referenced as a pension fund. It's a Provident Fund. And Mr. Belati's contribution would have been 5% of his franchise contract. That's what is negotiated. The Proteas players have a 7.5% contribution. And that's dependent on the player's remuneration. It's a percentage of remuneration. So no two players have the same value in the Provident Fund. What we do encourage all players to do is actually add to their Provident Fund payment. They've got a 15% tax-free amount they can pay. Some players do that. They take their commercial rights payments and they pay it into their Provident Fund, which is a very wise thing to do. And they walk away with significant Provident funds. If you're going to stick to the 5%, then you'll just have the 5% plus the growth over the period of your contract. So I'll be the first to say that, yes, players have different Provident Fund values. It's got nothing to do with race. It's like anybody else's Provident Fund. Depends on the contribution. The contributions are standard. Just on the fund, it's interesting to note the retirement age of our fund is 32. We made application to the receiver to help our players. They can retire. They can get the benefits that we non-players get at 55. They can get them at age 32. So players can assist them in starting up businesses, issues like that. It's a very dynamic and good fund in that regard. Mr. Mbalati says SACA is like a closed book and not transparent, and the black leadership does not have much say there. Sure, I disagree. SACA is transparent. Any member can ask any question of SACA, the business, at the AGM. I provide a comprehensive summary of all activities of SACA at the AGM to players as well. And the SACA executive and SACA presidents are directly involved in determining the direction of the organisation. Mr. Ramela and Mr. Zondo probably been the most active presidents we've had in the history of SACA, directly engaging on the various crises we followed in the last 3 years. So I cannot accept that statement. I won't go into the anti-corruption elements as we've discussed. I deal with Mr. Eddie Lee, the newly graduated LLB. And, I won't go into that. I actually provide clarity there on some statements he made. For example, Mr. Lee makes a statement that being a member of the Proteas squad cost him financially. That's not actually true. He lost out on about 3,700 Rand not playing his domestic cricket, and he gained 117,000 Rand from the Proteas Trust because he was a Protea. And I'm not doing that, and I explain the calculation there. I won't go through it with you. You can have a look at it. And I'm not doing that to point out Mr. Lee. I'm actually doing it because it illustrates the importance of understanding the different streams of income that players have. And that you need to understand those different streams of income to be able to put together a full understanding of, well, this is what a player earns in a given period of time.
Why do they not understand what it is that they have gone into an agreement with SACA for? If these were explained fully to them.
Yeah, education on all these matters is always a challenge for us. It's something we're always doing. And again, I, for example, sit with my team and I say, cheapers, if a guy's asking this at SJN, guys, we've got to do this better. We have some players who know every single cent where it comes from. So they listen to you and they actually come back and they'll say that 25 Rand, they're almost to the Rand, which is great. I actually like that. They're very finicky. And you have some players who have no idea where their money's coming from. And that's a challenge for us. And I think what happens is when players look back and say, gee, what happened there? Why did I get that money? But your point is well made in that it goes to our continual education of players on the earnings. You have to, one of our challenges, Mr. Chair, is you get the players for such a short space of time in a season to sit in front of them because how busy a season is. That's a challenge. Under COVID, it's been more of a challenge, and we've had to do things online. And that's part of the education. Your question is actually even more relevant when we deal with medical aid for players. So the players on the medical aid. You have a young player coming, age 21, 22. He's never been on medical aid. Now, you have to explain to him what medical aid is. And that's difficult because medical aid schemes are complicated. Even for me to understand them, they're complicated. Now you have to explain this to a player and how gap cover works.
And retirement annuity.
So that's a challenge for us. We recently... Yeah, obviously, you're thinking of the retirement annuity service. So.
It's 21.
Yeah. The player at 21. I mean, a player recently asked us, he didn't use his medical aid in a year, and he asked if he could have the premiums back. So we had to explain, unfortunately, it doesn't work like that. And he says, gee, but I paid all that money. And we said, yeah, but that's medical aid. So that's part of our challenge around educating players who are coming from different backgrounds, different understandings. And you can imagine a player who's never had medical aid suddenly saying, why do I need this? And you're saying it's if something happens. He says, well, I've never had to have this. That's a difficult sell. And it goes to your question of this as well. So. I won't deal with Mr. Tommy Tolekile. I've made quite a few points pointing out where he is incorrect on his representation. He was represented by attorneys elected by his agents. I said earlier I'll move on to Mr. Mayoli, so I'm there now on paragraph 109. Mr. Mayoli in his submission sent out the details of the incident with Mr. Robbie Farlink in 2016. And in the past year, we engaged with Mr. Mayoli on the incident and the role of SACA. And I can go back to 2016 and say that at that time, Mr. Tony Irish, who was the CEO, he engaged with the Dolphins franchise directly on the issue of disciplinary action being instituted to ensure that that matter between Mr. Farlink and Mr. Mayoli was resolved properly. I know that Mr. Irish also clarified that the disciplinary action would be initiated against Mr. Farlink and not Mr. Mayoli. Subsequent conversations between Mr. Irish and the Dolphins, we were informed that the disciplinary process had been concluded, sanction had been imposed on Mr. Farlink, and that SACA was also informed that the players had resolved their issues, with Mr. Farlink apologising to Mr. Mayoli. During 2020, Mr. Mayoli engaged with SACA and advised that he didn't actually feel we provided the requisite support back in 2016. So I, as the CEO last year, reviewed what we did, and I actually agreed with Mr. Mayoli. We did offer psychological support for him back then, but I think we should have engaged directly with him to offer support in the process. And the assumption that it was adequate for SACA to fight his cause by actively seeking disciplinary steps against Mr. Farlink due to Mr. Mayoli not being charged, I think that was wrong. Believing he did not require further assistance was, in hindsight, mistaken. Hence, at the end of last year, I apologised to Mr. Mayoli, which he went through in the forum, and we even offered him further legal assistance to possibly clarify any other issues he had. I do think we should have gone back to Mr. Mayoli after the event and said, the event's concluded. Where are you standing on this? Are you happy how it's been concluded? Because now it comes out he wasn't happy how it's been concluded. And then I think we should have, and that is hence my apology. I think that was a mistake on our side. That experience of dealing with that issue has led us to looking to have our own third-party assistance when we're dealing with disputes between players in that regard. So, in other words, we'd actually coined the phrase before you'd arrived, our own ombudsman, to say, how does this person, is this an issue of discrimination that we need to look at? How do we assist this person? Rather than saying, well, the province dealt with the issue and concluded it, and everyone was mistakenly happy with how it transpired. And that's where we ended up with actually dealing with that issue and making the apology to Mr. Mayoli. I think he's right. We should have gone back to him and seen how the process has unfolded. He does state in his affidavit, which I think is unfair. I do not matter to SACA because I am black. It's disheartening to hear that. I do believe that in the submission I've presented a lot of information to prove that black African players are important to the SACA cause and enjoy all the benefits other players enjoy. I do agree that it's imperative that the leadership of SACA is sensitive to the plight of black African players, which is a statement he made. I'm very conscious of that, and I think that's a key performance issue under my leadership. And like I said, the appointment of Mr. Wachipa was directly related to us being able to engage with black African players. I accept, Mr. Chair, I'm a 52-year-old white male. That in itself is an issue when you're dealing with a young black African player who's 22. And that is one of the reasons why we've taken those actions. Mr. Mayoli also references our last year's AGM where he was present, where I said we'd be putting on seminars. Slightly mistaken there. I'm not into seminars. We're not putting on seminars on diversity. Our intervention, for which the executive set aside R1 million as a start, is to assist teams, to facilitate with professionals, to have the in-depth discussions on race. and culture and transformation. Only if we have those hard discussions do I think we can start dealing with that fourth foundation that I speak about, the actual diversity. We've started that, and it started in September. We've been to Gauteng, we've been to Free State, and Northerns and Northwest happened yesterday. And it's very interesting. We're getting reports coming back, and we're getting a collated report for our next steps in that action. But what is interesting is the feedback we've had from some players. Some players feel very uncomfortable about it, which, as Mr. Wachipa said to me, that's good, because people are meant to feel uncomfortable about it. We had other players saying they've never been able to talk so freely about issues of race that affect them within the team context, which is very constructive. We've had a player come to us and say, I'm a white captain, I'm not quite sure how I need to manage a black African player given BLM. I don't want him to think I'm taking him off because he's black or putting him on because he's black. But a black African player say, I don't want the captain to think he must bowl me because I'm black. He must bowl me because he needs to bowl me. And we're unpacking a lot of those issues in these sessions. So we've got it professionally facilitated. We went through a tender process for it to try and find the right people to do it. And this is the first step in that process. So arising out of a lot of what Mr. Manyoli has said, actually we've made some changes. We've implemented things to improve things. They're not seminars. I would be the first person to say a seminar is boring. They're actually interactive and proven to be quite challenging engagements, which we will be going on for the teams as the season moves on. We'll move on to Division 2 probably in the new year, but we'll hopefully finish Division 1 in this year still. And the SACA executive is willing to set aside further money. Of course, it's not just once off, it's follow up and follow up. And that's the process we be implementing. Okay.
In Ramela?
Sorry, sir. Is it now? I was wondering if I've got my urgent 4 o'clock.
Oh yeah, it's 5 to 5. 5 to 4 now.
And then I shan't be too long thereafter, Mr. Chair. I hopefully won't be longer than 15 minutes in my meeting.
I don't know if you can take a chance. Meetings go on forever.
No, I will make sure this is quick, sir.
If I adjourn now, I want to adjourn for the day. But I'm conscious of you having come from Cape Town.
I believe I need another 30 to 45 minutes after my meeting, Mr. Chair, which...
I've heard that before. We can do it virtually.
Okay.
Why are you resisting virtual hearing for an hour?
I believe in the personal engagement is much more constructive.
You've heard that for 4 hours today.
Much more constructive. So we'll adjourn. I'll finish off my last... Well, no, then I'll make it an hour. I'll penalise you. I'll go longer.
It's okay.
Okay.
I'm prepared.
Mr. Britsky, we must apologize though for the unforeseen delay. We didn't obviously expect for some of the hearings to carry over.
No, not on this one. They made an arrangement with Mr. Becker.
I thought Mr. Becker was starting at 9. That was the difference.
But you said he can take some of your time.
Yeah, I thought he was starting at 9. I said to him, if you start at 9, you can take my time. So he owes me.
So let's adjourn to a virtual platform to 10 o'clock tomorrow.
Okay, and then I'll finish off, and then okay.
And good luck with your meeting.
Thank you, sir.
Are you online?
I'm online, yes.
Oh yeah. You better get there.
Thank you.
You never know. Yeah.
Thank you.
We're adjourned till 10 o'clock for the record.